And raise 3 matters, my lord. One para may be deleted. I have marked, my lord, because this para does not applicable. Raise for 3 matters. I have marked through pencil, my lord.
Let's show me.
This is the first matter. Next, my lord, second, third. I have marked through pencil, my lord. That para is not applicable in 3 cases.
Let that remain.
Yes.
That is not going to hamper anything because
My duty, my lord, my duty to law in the
very well. That is not going to hamper.
Yes. And
submission part. The corrections I will do.
Yes, my lord. Yes.
Corrections will appear. Para deletion I will not do.
Yes.
And then
And for that, my lord, for
that you take out an application, small application that please pass this order. I will pass that order.
Only indicating this point.
Yes, that if I pay 5 lakhs, that may be released. So that will come up.
My lord. And second, my lord, that on income tax matter, my lord, they issued notice. I am challenging 148 AD order, my lord. They last Friday, my lord, they issued notice asking for a stay order. I have attached. Upon notice, I am mentioning if do not get a stay order, they will proceed. Very important, my lord, urgent, my lord. I am praying.
My lord, this is an urgent matter which was not in the list, it's including the list. So since the final hearing is there tomorrow, so we would request for the motion to be heard, my lord.
It is there in the list.
Yes, my lord.
Yes, then it will have to be upgraded then.
Yes, my lord.
Okay, upgraded. You have written the grounds of
Yes, sir.
Yes,
I will not to mention the matter for inclusion in the constitution.
please.
May I be permitted to mention item number 53 to the previous policy? Your lordship, the matter pertains of cash, and your lordship in a similar matter.
453 টাকে ইয়ে করে দিন, urgent motion এ দিয়ে দিন।
Your lordship, I am mentioning for upgradation. The matter is already listed in the daily list today, 520 and 521. The respondent authority, they are not serving any order in original or so-called notice, but now they are seizing the bank accounts and the sundry debtors of the petitioner. So the petitioner's business is really in trouble. So if there is the upgradation, that will be.
Please mention the grounds.
Yes, ma'am.
This matter is 141 today's list. It is a squarely applicable, 168 a challenge, squarely applicable. In the meantime, department issue intimation of recovery proceedings. Now they are taking fake phone calls to take coercive action. So kindly
168 matter against what?
Once the constitutional validity challenges the constitution.
That's right, but you have challenged the adjudication order or the appellate order?
Adjudication order.
After how many days? You had opportunity to prefer appeal.
Yeah, my lord.
You had opportunity to prefer appeal. Have you preferred?
No, I feel prepared, and now dismiss.
I'll see it, and then it may not be upgraded if I find that you have challenged the adjudication order beyond time. এখন নয়, ফাইলটা দেখলে।
Lord, may I have to mention, Lord.
What is for the extension of interim order? এক্সটেনশন অফ ইন্টারিম অর্ডার দিদি কাল থেকে এক্সটেনশন আবার দিতে আরম্ভ করে দিন, কারণ এসব একদিনে অনেকগুলো হয়ে যাবে, কিছু কিছু রোজ রোজ দিয়ে দেবেন।
Your lordship, serial number 470 of your lordship's today's cause list, your lordship, the urgency in the matters that bring for upgradation, your lordship, the urgency that we have received the recovery notice from the GST department, your lordship.
473.
470, your lordship.
You have mentioned the grounds.
Yes, your lordship. I have attached the recovery notice.
Please mention the grounds also.
I have.
Yes. Inclusion, please give. Please give. I'm not upgrade hearing matter today only. Please give if you want it to be included.
May I be permitted to mention, your lordship?
Hearing and mention inclusion, please give.
Lordship,
Extension of interim order expiring on 19th.
Lordship,
19th. ওটা দেখুন দিদি, ওটা কালকে দিয়ে দিন।
Lordship, this is with regard to item number 298 of my lord's list, my lord. My lord, this is simpliciter consideration of representation matter, your lordship.
298.
Lordship. Yes. Lordship, the petitioner has sought for a benefit under the double taxation avoidance scheme, your lordship. My lord, that right has been decided up to this court, your lordship. And my lord, thereafter we have made a representation. I'm just simplicity praying for consideration.
298 টা দিদি urgent motion এ দিয়ে দিন। You have mentioned your grounds of urgency.
Lordship, may I be
my lord, I'll
please write the grounds of urgency and give so that it is easier to say.
permitted to mention the matter, Lordship. Your Lordship, this is item number 716 of your Lordship stated it. It is a hearing matter, Lordship. Your Lordship had heard the matter, Lordship, in the month of September. Now, your Lordship, this matter was supposed to come in the list of November, but despite mentioning it didn't come, it has just reflected in today's list, your Lordship. Lordship, I'm mentioning for upgradation, Lordship, the petitioner is in custody for over 22 years and is suffering from health issues, your Lordship. If your Lordship may kindly fixes a date for hearing, Lordship.
Very well.
We have
700 and
submitted a compendium of judgments also.
700.
716, your Lordship, of today's
Give
list.
this slip.
With your lordship's leave, my lord, if I may mention.
Yes,
Your Lordship, may I be permitted to mention item number 312, Your Lordship. A recovery notice has been issued in this matter, Your Lordship. A recovery notice has been issued.
এটা হিয়ারিং এর ওই উপরে আসার কথাও ছিল, এটা দিয়ে দেবেন।
Your Lordship, item number 312 of today's cause list. Your Lordship, a recovery notice has been issued in this matter.
দিয়ে please.
With your lordship.
My lord, may I be allowed? My
Yes.
lord, may I be allowed to mention one matter? My lord, it has appeared in the list of today and as item number 51, but the electronic credit ledger of our petitioner has been blocked and hence the urgency. My lord, if it could be
কালকে
upgraded.
দিয়ে দেবেন। Urgent.
Grateful, my lord.
For upgradation. My lord, item number 563. Now the item pertains to, my lord, the matter pertains to disconnection of public water supply to the petitioner's paddy field. My lord has been hearing it for a while, my lord. Now, my lord, I'm praying for upgradation because, my lord, the agriculture season has started. And if my lord doesn't dispose it off, my lord, I will not be able to supply water.
516.
63, my lord. It is under specially assigned, my lord.
563. Very well. Give it. We shall see.
My lordship, I am mentioning in my urgent.
You have given your urgency grounds of urgency. দেখুন তো দিদি, আর্জেন্ট গ্রাউন্ডে এই সবগুলো একবার দিয়ে দেবো আমরা। আজকে নিয়ে আসবেন। You have mentioned your grounds of urgency.
Mentioning the determination of honorable justice, my lordship. The matter was fixed before the trial court on 20 December 2025, my lordship.
Before which court?
Before the trial court. Coming Saturday, 20
Trial court.
Trial petition. The matter was the petitioner filed a suit for suit under section 30.
That determination I don't have. It is only group 1. Yes.
With your lordship's leave, my lord, if I may mention, my lord, just mentioning upon notice, my lord, these are two connected, my lord, writ petitions that had been taken up last Wednesday, my lord, was supposed to come up today, my lord. However, my lord, it's not in the list. my
Which
lord.
one? Which matter?
My lord, one was for withdrawal, my lord, and for refund, my lord. For waiver, my lord, to appeal before the Honorable Stat, my lord. It's the EMTA Coal Limited versus Union of India, my lord. And if you may just hand up the slip.
No, you prayed for time. That is why it is not coming.
My lord, it was supposed to come up today, my lord.
Maybe it will be listed tomorrow.
My lord, if it may be listed day after, my lord, because tomorrow, my lord.
নিয়ে নিন, দিয়ে দেবেন। To be mentioned আসার কথা ছিল। To be mentioned ছিল তো। Prayed for time.
Yes, my lord, we paid for time, my lord. It was supposed to come.
Blaming the court
Ma'am,
for that.
today, my lord, it was
My
supposed
lord,
to come.
today we have a,
It wasn't supposed to come today.
my lord, in your lordship has fixed a matter for today for in item number 28, DKT was Union of India. My lord, we have a similar matter tomorrow, which is against DKT versus state. So if my lord could kindly fix the matter tomorrow, my lord, together as they are connected.
Item number?
Today 28, my lord. DKT versus Union of India. Oh, sir. No.
Item number 28.
Yes, your lordship.
Very well. You pray for time at the time of call. I'll
Okay.
take it to court. Yes.
May I have my lord kind leave to mention a matter, my lord?
Yes.
Millard, this pertains to Millard, the group 2 matter, Millard, wherein Millard, the college authorities, Millard, has retained Millard the original academic documents of the Millard petitioner, Millard, who is a student, Millard, was studying over there, Millard. Now, Millard, we have made Millard persistent representations, Millard, they are not releasing the same, Millard. Millard, this matter earlier was heard by Millard, His Lordship, Honorable Justice Patrocedings, Millard, but Millard, subsequent to the change of determination, Millard, this will be heard at this juncture, Millard, it will be heard by your Lordship, Millard. Millard, affidavits have been exchanged by and between the parties, Millard. Now, Millard, in the absence of Millard, the original academic documents milad, starting from milad the board results to the milad graduation certificates milad, all are lying milad with the milad college authorities milad. Milad it is causing milad serious obstruction milad to her academic and professional pursuits milad. Milad all I am beseeching before your lordship is milad that milad if the matter may kindly be heard on an urgent message milad, and the same can be included in your lordship's list milad.
Give the slip, it will be included.
Very well milad. Grateful to your lordship milad. Have all right.
এই unauthorized documents এর হেডিং এ 25 নম্বর আজকে উঠেছে কেন? না তো এটা
Malaysia, I think for it's not correction. Cause title is different in the in the order sheet or lordships. Cause title to be corrected.
ও কস্ট টাইটেলটা ভুল আছে। There is a mistake in the cost title.
Claim for extension of interim order, exchange of affidavits, it's completed.
লিখে নিন। This matter is appearing under the heading
We also similar, my lord, affidavits have been exchanged.
affidavits are complete.
Yes, ma'am.
Who is appearing? Mr. Chakravarti,
Yes.
you have filed your affidavits. Filed your affidavits, sir?
My instruction affidavits have not been filed.
This is big letter of text.
There is an affidavit in reply on record.
Yes, on the last occasion we have filed the reply. The opposition must have been.
Affidavit in opposition filed in court today, there is a recording.
Then it must be filed.
We have filed reply.
Yes, affidavit in opposition is there. লিখে নিন।
Don't have a copy, I'll take a copy.
Same order. Same order করে দিন। Monthly.
Consideration of pre-show cause reply, not consideration.
No, the issue has been decided by the Honorable
There are
Division Bench.
some differences there.
Look at the copy.
Wait.
এটা তো আছে।
Wait.
Madam can fix the matter any day, madam, as you know. Otherwise,
of December করে দিন till the end of February. Let the matter appear in the combined monthly list of January.
grateful, madam. Grateful.
আগেরটাই, under the heading head.
আমার দুজনে একটা মালা করে দিল।
Must same manner. This next period is different. Madam.
Affidavits complete.
Yes.
ঠিক আছে। এটা নিয়ে নিন। Same order. Same. February and January.
আমাকে ফোন করো। করা যাবে না। Copy নেই বেকার। Item number 5 might not appear before the respondent.
এটা রিলিজ দেখবেন, অর্ডার ঠিকঠাক করবেন। আগের মতন ভুল অর্ডার আপলোড করবেন না। এর অর্ডার ওর।
Kindly see the order dated 6th of August 2020.
Yes. This matter stands released from my this matter stands released from this list on six.
অর্ডারটা বার করে।
Lordship, here the extension expired on 30th November.
Yes,
This
yes.
file, Lordships, we had mentioned is mandamus at the end of the day.
I'm reimposing and
But I have not said anything.
Lordship, the last order was passed on 22nd of February, 22nd of May.
This matter is
25th of
under the heading-
September. 25th of September.
under the heading extension of interim order on being
the report, and based on that, this court will dispose of. It is not for exchange of evidence.
Why don't you do it then? We can finish off this.
Lordship, this the in fact the additional
January monthly list করে দিন same.
Grateful.
Your Lordship, I beg to appear on behalf of the petitioner, my lord. My lord, the interim order is expiring on the 15th by the order dated 14th October 2025.
So till today it is there.
Yes, my lord.
So is same order করে দিন. Affidavits have been filed.
No, my lord.
লিখে নিন। ওই চেয়েছিলাম বাড়িতে পেলাম কি ছিল
SOD scheme under 128A. My SOD application stood rejected on the ground that I have not filed a reply. In the rejection summary order,
Take me through the orders again.
Lordship.
Because it has gone out.
Lordship, I'll just take 2 minutes to give the brief background then once, because the
Take me through the papers.
Lordship, Lordship, a show cause notice was issued on 27th of December 23 at page 37
Yes.
by the department for the period 18-19 and 2021, 2 financial years, wherein demand of 2.46 crores was
Just a minute.
Lordships.
Page 37.
Page 37, Lordships, relevant period is 18-19 and 2021.
Yes.
And at page 42, Lordships, out of the total demand of 2.46, clause number 4 appropriates 2.30 crores, which was already paid before issuance of show cause. Lordships, then Lordships, a demand order against this was passed at page 55.
So it records that since 2.30 and odd crore has already been paid.
Then why it should not be appropriated? In the demand order, it's appropriated. I will show it, Lordships. That was a show cause. So it says why it should not be appropriated.
So there were 2 reasons. One was 2.46 excess availment of ITC.
Out of that 2.30 paid.
2.30 you had already paid. Why it should not be appropriated
Lordships.
against the demand?
Lordships.
Mentioned
In the show cause itself.
in the show cause.
Now, Lordships, page 55 is the summary demand order. After this, the demand order came to be passed. Detailed order starts at 50.
This 2.30 had been paid under protest.
No, prior to it was accepted. It was a reversal of credit.
Then, I just want to understand then what is the reason of not appropriating?
Lordship, they appropriated it while passing the order. In the show cause, they say this you have paid, this is the status, because they will impose penalty on the total amount, not on the balance amount.
So for that reason.
For that reason.
Otherwise, this is a.
Lordship, state appropriates it at the show cause stage only. But central always, because they want to impose penalty on the entire demand, a 10% penalty on 2.46. Therefore, they appropriate in the order.
Because otherwise it becomes meaningless.
Meaningless.
Because if you have paid it,
Lordship,
you have paid it for
just for the
appropriation.
penalty.
You cannot pay it and ask for return of it.
Lordship.
Very well.
Lordship, page 57, the demand order came to be passed.
Page 57.
The demand of the Star's Lordship, detailed or the relevant order portion is at page 73.
Page 57.
57 it starts Lordships. It confirms the entire demand at 73. Lordship may take 73, para number 6, order.
The entirety of 2.46 is.
Lordship, the entire amount was confirmed, and in the clause A, 6A, I also order for appropriation of 2.30.
Right.
Now, Lordships, against this, I file an appeal at page 75.
Just a
Lordships.
yes.
Page 75, I file an appeal, Lordships.
Page 75.
75 APL 01 is there. The date of filing is at page 77, Lordships. Left hand side, 28th of June 2024. 77, left hand side, place Kolkata date.
Yes.
Now, Lordship, in the meantime, now the department CBIC comes up with the amnesty scheme under section 128A, which says that if for the period 17, 18, 18, 19, 19, 20, any show cause has been issued or any
that?
Lordship, that scheme.
Yes.
That scheme is at page 172. I have extracted the provision.
Yes, that is what is required.
My application is there in
Page.
my SPL2 application, Lordship, at page 104. 104, 105.
I just wanted to be handy with the
Lordships.
Yes.
104 is the date of creation. Lordship may see this is a screenshot. Date of application 12th of June 25 in page 104.
And when was this at page 103?
104, Lordships.
No, the amnesty scheme, when was it notified?
Lordship, that is at page 172. That's the legal provision, Lordship, at page 172. With effect from 1/11/24, it is given in the extract of provisions, Lordships. Page 172. 172, my lords will find in 173, inserted by Finance Act number 2 with effect from 1/11/24. Next page, 173, first line, my lords will find that. The date of enactment.
172, 128A.
Lordships. And 173, the footnote 28B. It was enacted from 1/11/24. 28B, Lordship will find at 172, top left hand side. Waiver of interest or penalty, Lordship, that side 28B is there, footnote. That footnote is given from 1/11/24.
So it was not under any scheme which was notified.
It was a provision inserted to give the benefit, because Lordship, it is not there is no end date to scheme. It is still valid today also. The scheme is still valid today.
Because there is no scheme, there is a provision.
There is a provision, statutory provision.
It's not a scheme.
Yes, Lordship.
If it was a scheme under a provision,
then it would have been a
Lordship would have had shelf life.
Shelf life. It has no shelf. It had shelf life in the context that I have to apply within a cutoff date.
Right.
But still today.
There is that provision in this that you have to apply within what
Lordship,
time?
128, Lordships.
Yes.
The relevant rule would be, Lordship, 164 at page 174.
And this was notified during the pendency of
my appeal. Lordships.
And what is to be done for one to become eligible under this?
Lordship, I had to pay the entire tax within 31st of March.
Entire tax means whatever is assessed.
Order is assessed. I cannot dispute that tax, either in the show cause or order or appeal.
So in this, it was 2.46.
Lordship, there were two periods, 1819 and 2021.
That was the cumulative sum.
Lordships.
2.46
was the cumulative sum.
And 2.32 pertain to a particular period.
2.34 pertain to 1819 out of this.
So that you had paid in entirety.
I have paid in entirety. And therefore, I applied for this scheme on 12th of June. My Lordship will take page 104 for the date.
104.
104.
Yes.
Date of application, Lordship, is in their third line. 12th of June.
Issue date.
Lordship, date of application, case creation.
Yes.
This is 12th of June.
Top.
So this is my application. Page 105 is the application copy. SPL2 filed on the portal. Because in the portal acknowledgement there is no date, Lordship, therefore we have to give that screenshot. Page 102 to 108.
And at 106, you mentioned it April 18 to March 19.
Lordship, that is the period covered. Now, Lordship, because my appeal was pending, the board came up with a circular in such type of cases, what will the appellate authority do? Because one period is in amnesty, one is without amnesty. So board instructed that we have to file a letter to the appellate authority that we are willing to go for 1819 amnesty. The appellate authority will allow me to withdraw the appeal for that period and pass orders for the period not covered under amnesty. So, Lordship, I wrote an email at page 109 to the appellate authority.
Yes.
Page 109, my Lordship will take.
106, 7, 8, 9.
109 is the email given by me to my appellate authority.
Yes.
Where in the subject I say, I refer to this appeal number and payment of demand under for 1819 under 128A for waiver of interest on the same. And then I request at page 110. Page 110, second last paragraph. In light of the above, we earnestly request you to consider this while issuing the final order in form APL4. Furthermore, upon submission of SPL2, we shall provide a copy of the same. Now, Lordship, board circular to this is very important, Lordship. Under what authority I have done this? Lordship, may take the board circular at page 101.
101.
101, Lordship, some pages.
No, not.
That in the sequence of drafting, it was first.
101.
101, Lordship, circular
27th
248, 27th March. Lordship, may kindly take issue number 2, which is at page 103.
Consolidated adjudication, covering period beyond the one which is
Lordship, page 103, where issue 2, 4.2. This is the issue. May I place it, Lordship? Whether the entire amount of tax is required to be discharged and appeal is required to be withdrawn for the entire period, where notices pertains to period covered partly under 128 and partially outside.
You did not want to pursue the appeal for that period,
Lordship,
which you had already paid.
And therefore, I had to give a letter to the appellate authority, which I did.
The appeal will stand withdrawn as regards 2018.
128, only to that extent. Now, Lordship,
1920 or whatever the
2021, he will pass the appropriator, which I will take it to tribunal in the regulars. Now, Lordships, in the meantime, the appellate authority confirms the entire demand at page 144.
144
is the summary of the APL4.
Page 144. Yes.
This is the summary order, Lordships. The findings. Kindly take, Lordship, page 160. He comments upon 128A, which was beyond his jurisdiction. He says, I am not eligible for 128.
160.
160, para 9.5. He goes on to discuss 128A applicability, which was beyond his scope, because he has to follow the board circular and along with the withdrawal to that extent. But he, Lordship, extracts 128A and 9.6 what he writes, Lordship. On perusal of 128A, I find that the waiver of interest under 50 and penalty under the state tax is applicable when the appellant has already paid the full amount of tax payable. In the instant case, I find appellant has wrongly availed credit of the amount of 2.14 during 1819, against which the so-called order were issued. But the appellant reversed 2.10 only, and the balance of 4.01 have not been reversed, which is wrong, which I have already reversed on 31st of March and submitted him the proof at page 104, which I have shown your Lordship.
And how is this section to be interpreted? Has the board circular rightly interpreted this?
No, Lordship, he has not considered that. He has missed my email. He has not taken that into account and passed this order. In fact, Lordship, he knows the email has been given. Therefore, he speaks about 128, but he does not go into the board circular. He has not discussed the board circular in any place.
What does section 128 say? That he says that, does it say that?
He says, Lordship, 128A says, to be eligible, I need to first pay the entire tax and then filing after 3 months. So he says 2.10 you have paid, 4 lakhs you have not paid, which is already paid within the 31st March. This is not the end to the story. I'll just take your Lordship. Now, in the meantime, my SOD application gets rejected. My application for waiver, which I had filed at page 104, my lord, at SPL 2, department issues me a show cause under that application. Kindly take 120. 120 is the show cause notice under for my SOD application. He wants certain payment proofs in the show cause, lordship. On brief facts of the case, the taxpayer has not submitted payment particulars of pending tax dues in full. He gave me a show cause.
This SPL 02 is the amnesty thing.
Yes, lordship. SPL is for special provisions. Therefore, SPL 2 is the application. SPL 3 is the show cause. SPL 3 he issued me a show cause. I replied at page 125. 125 is the acknowledgement of my reply, lordship. Kindly take the date, lordship. 20th of July, I replied. 125, top right hand side. And my detailed reply, 127. Wherein I gave him the entire table and I submitted my details. Now, lordship, he passes the order at 135. Kindly takes 135. He rejects SPL 7 order for rejection of application. Lordship, may kindly see there is a table. He says reply to the show cause. Lordship, third line in the table. Reply to the show cause, date he records at 20th July.
Yes.
Now, lordship, kindly sees 136. Who is uploading this summary? Assistant Commissioner Pingur, Mr. S. Bhowal. Now, lordship, detail order starts at 137. 137, lordship. Who passes this order? Charged by Sri Jugal Krishna Paul. Because the incumbent, he was the incumbent at the time of uploading, some other person was there. Lordship, what he writes in 137, lordship, kindly takes 139. The detailed order.
He did not submit any written reply.
Taxpayer's written reply to SPL 3. The taxpayer did not submit any written reply in SPL 3. The taxpayer did not submit any reply through the portal either. In fact, taxpayer did not submit any reply in any form whatsoever. And then, lordship, again, at page 141. Page 141, last line. But the taxpayer has neither submitted any copy of 3 and not submitted any reply. Page 142 again in the middle paragraph. Taxpayer has not submitted any reply. And therefore he rejects.
What is the DRCA 3A?
DRC 3A, lordship, it is like once we pay a payment under, there is a form DRC 3. Now, once 128A came, the GSTN came up with another form 3A to set off this payment with the appropriate demand orders. So there can be 10 demand orders against me. I have made a lump sum payment of 5 lakhs. Now this 5 lakh is against which of these 10? A form is there in the portal to appropriate that against that. That is 3.
So that you had submitted.
That I had given a reply that why I am not able to submit. Lordship, may kindly take my reply at page 125. 125 the reply, 128A. In my case, that is not applicable. Page 128, serial number 2 of my reply, lordship.
Yes.
Non-submission of copy of 3A. The notice is amid that in accordance with Rule 162, 4 Subrule 2, read with the Subrule 2B of 142, the requirement to file DRC 3 arises only in case where payment to a tax has been made through form DRC 03. Instead, under the payment facility, payments toward demand made under the portal. The purpose of filing of 3A is to link the payment made via 3 while the corresponding demand order so as to enable the proper adjustment in the liability register. In the present case, the notice has discharged the confirmed demand directly by utilizing payments toward demand.
Since you have paid it
Through the portal directly.
in
Therefore,
relation to a particular year, therefore there is no question of any ambiguity
Lordship.
for which you had to
Lordship.
verify it by
I will. Lordship. And lordship, after that, I filed a application for rectification before the appellate authority. He is sitting tight over it more than 4 months ago. So, lordship, in fact, the rectification not required, lordship, the appeal authority order has to go. This SPL rejection has to go and both has to be remanded. That is my only point.
Formal objection.
Objection on what ground? Take the
Over here, we will be submitting
Do you say that the board circular is not applicable to you, or the board circular is?
Board circular is always applicable to the officers who are
No,
discharged.
you can say this if you can say that the board circular is not in terms of the statute. That is the only thing which you can say. No, you can say that. That is what Supreme Court has said.
Yes.
That the board circular will be binding on you if it is not in accordance with law. If you can say that no, this cannot be, then in that case it will not be binding on anybody. Otherwise, it will be binding on the authorities. That is the statement of law. It was clarified later on. Earlier it was that it is always binding.
Earlier it was blanket binding.
That was Varghese. Varghese was the
Okay.
first one which said that
it has to be followed,
then Justice
even if it is wrong.
Justice Lalit's judgment later on which it came, which said no, it has to be within the statutory framework. You
The
cannot
circular has to be challenged in that case, Lordship.
in any case, if the court can interpret
Lord,
it,
the
if
court
that
can
is-
interpret. Lordship.
that is said by the department, then in that case I can interpret saying that no, the circular will not be binding because it is going
Well, no,
beyond
we
this.
are not going to such an extent.
Yes,
Sir, we are
that
not-
is why I wanted this from you.
We are not going to such an
Because I'll
extent.
be recording this in your objection also that you are not saying that the board circular is not applicable because he has not taken into consideration that. And prima facie it doesn't appear that the board circular is.
There has been
devoted-
proper application of mine over
Yes.
the whole issue, which led to jumbling of facts and disposal of the cases without.
So he should be given
Yes, sir. Both should be remanded for.
remanded, and why should he not be given the benefit of this circular?
That has to be clarified by the Lords. Otherwise, again, a new issue will come up. They will interpret as per that is my prayer, Lordship.
They will
The
be bound by your Lordship's order. My Lordship may remand it back with the direction.
with direction. For the period 18-19, at least appeal authority.
He should be given benefit of the circular.
Lordship. And the normal application, the proper officer will reconsider giving me a hearing because my reply is on record.
No, no. Two separately should be paid.
Joinder of causes of action is permissible if the petitioner is one. If there are two petitioners with separate causes of action,
Multiple. He's challenging.
joinder of causes of action is permissible in a suit also.
Because of one other is there.
And the other is consequential.
Yes.
Get a copy. Well, I am for the petitioner, my lord. My lord, for the period for as financial year 17-18 to 21-22, for the 5 periods, my lord, they have initiated the recovery proceeding. My lord, then the adjudication order has been passed under section 74 of the Act. My lord. And what happened in this case, my lord, earlier we have already moved an application for the 1 period.
আরেকটা নতুন যেটা তোকে বললাম সেটা সকালবেলা
Order passed by the Honorable Court for the period 21-22.
Appellate authority's order you have challenged or you have
No,
not?
no, no. We have challenged only the adjudication order belatedly, my lord. But there is some reason, my lord, we come late before this honorable court. And that is why the 50,000 cost was imposed. Well, I have paid that amount. But the, my lord, kindly come.
compared to my lord what imposition of cost it is
Little.
my lord is little.
Well, page 87 of the kindly come to page 87 of the petition, my lord.
আরেকটা কপি দিতে হবে একটাই না
Yes.
My lord, the 21-22, my lord is saying that WPA number 2558 of 2024 on
This one.
20 this one, my lord. The other 4 period, my lord, we are filing petition with item number 9, 10, 11 and serial number 460, 449 of the today's list, my lord.
I have also done some homework. This is the recovery. The department থেকে বার করেছি।
Well, I am ready to pay. That is why I am submitting everything. When it is on record, everything on record. My lord.
Yes, yes, not let them go back to the applicant.
Yes, my lord.
Motion matter should be treated in a motion way.
Well, I am not.
No,
If
he is-
required, if required,
he
then
has
only
always
I can argue, my lord. Otherwise, unnecessary.
He has always been
The
fair.
court's time, man.
Because this is not something which requires
Yes, has to be.
লিখে নিন দাদা।
All the orders are same, my lord. Same date. So only the period is different.
This writ petition,
Not true. 18,
Then 1718 and 2021.
10,
10 is 1718. They have recovered, my lord.
Further recovered.
The true deposit of two.
1718, it will be, this portion will not be there.
Yes, ma'am.
This 10% free deposit will not be. 1718 is same জিনিসটা থাকবে, মানে item 10, item 10 এ লিখে নিন, same জিনিসটা থাকবে, শুধু এখানে রাইডার লিখুন
Yes, yes.
যে since it has been since it has not been disputed. Same order. We are keeping it same.
Yes, ma'am. Item number 11, period is 2021.
Same order. Last এরটা কপি করি। 10 আর 11 সেম হচ্ছে। তিনটে হলো 9, 10, 11। 9 টা আলাদা হচ্ছে, ওখানে কস্ট ডিপোজিট হবে, আর 10, 11 সেম হবে। আমি বলে দেবো এই অর্ডার থেকে আপনি কপি করে নিন। 9 টা আলাদা হচ্ছে, 10, 11 সেম। Yes,
I am for the.
there was a direction, no?
Yes. Lord, kindly see your lordship's last order in that 4009.
Yes.
And also 8510. Lord, direction was that they should file a report in the form of an affidavit. And Lord, they should also, Lord, take instructions with regard to the grant of Lord exemption.
Yes, Mr. Datta.
Milord, we have received a written instruction, Milord, from this department, that which says, Milord, that the competent authority has stated that the case is under active consideration of CBDT. And they have asked us to, Milord, pray for an adjournment.
But where is the affidavit? I had asked for a report in the form of an.
What that? That's there.
Lord, we have challenged the CBDT's order, which says that it can be granted from 2020-21 and not before.
Yes.
No,
because
it is being considered afresh by the CBDT. And
no, no,
Milord,
There's no question of, kindly see page 7,
They had in the last order, which was placed.
page 78, Lord, of 4009.
Yes. At page 79, in paragraph 2.2.
In
Rather,
fact,
page 80.
yes, Lord, page 8.
Page 80.
Yes.
Clause 3, 6.2.1 III.
And in fact, Lord, before that, the department had sought, Lord, clarification from us, which is at page 56. If your lordships, Lord, take that, where, Lord, we said that we are prepared to surrender.
Because I had quoted that part in the order also. Page 2 of the order, I had
Yes.
quoted that, so that things are clear. Is liable for exemption, should have been entitled to, but anyways, that he is entitled to exemption.
yes, may I say this? As it appears, which have been communication between Mr. Sharma and the department, they have sought for 4 weeks time to file that affidavit. That is what I am instructed. Now, Millard, what I would suggest, Millard, is that it is apparent from the record that they are entitled to exemption. So whatever is in dispute is from 2016 till 2020 and not thereafter. So, Millard, whether they will get retrospective operation or prospective. Millard, so Millard, kindly stay the demand, and we shall file an affidavit.
Yes. He can.
affidavit.
Yes.
Well, my application, my lord. I come after the appellate authority has passed the appellate order, my lord. My lord, lordship comes down for a moment, my lord, to page number, my lord, 34 of the petition, my lord. But there are 3 allegations against me, my lord.
34.
34, my lord.
এটা কি দিয়েছে?
14. Sign for much.
Yes. Page
34, my lord.
34. Yes.
My lord, at the bottom, my lord, there is a box.
Yes.
So in the box, tax short paid on outward supply is 5,002.07, my lord. Thereafter, my lord, ITC availed in excess is, my lord, 22 lakhs 570.52, my lord. And the third is ITC found reversible if applicable is for 1 crore 74 lakhs 45,591, my lord. My lord, it is under IGST tax, my lord. Now, my lord, here, my lord, first 2 point is as regards to my supply and excess ITC availed, my lord, that has been settled in the appeal, my lord. Only as regards to, my lord, this IGST of 1 crore 74 lakhs is in dispute, my lord, which I have come before your lordship, my lord. Well, herein after, my lord, lordship comes down to, my lord, page number 39, my lord. Breakup of this 17 crore 74 lakh is
39.
39, my lord. Lordship, come, my lord.
39.
Yes, my lord. My lord, 4C is 4,997.41, my lord.
4C.
4C, my lord.
Yes.
And thereafter, my lord, 4F 174.4594.
4F. Yes.
My lord, 4C is as regards to, my lord, my non-proper declaration of place of supply, my lord. That is 4,997. But 4F is ITC found reversible in respect of credit note received, my lord. That is my input tax credit which I have availed, my lord. It has to be reduced, my lord. Now the problem is in the return, my lord, there is no column whereof I can show a reversal, my lord. I can reduce the quantum of ITC availed, my lord, if the current ITC is lesser than the amount of credit note received and the ITC is to be reversed, my lord. Say, my lord, in this month, my lord, I am having an ITC of 100 rupees, and my lord, credit note is showing a ITC of 200 rupees, my lord. I cannot show it in the return. But now what the law says, my lord, 42, which has been omitted, my lord, from 1/10/2022, my lord, it says that I'll have to increase my output tax liability, my lord, by that amount. That means the quantum of payment is to be enhanced, my lord. But now what I did was, my lord, 41, my lord, lordship comes down once, my lord.
You are challenging the adjudication or
no? Appellate order. Appellate order. My lord, 41 and 42, my lord, some payment has been made by me, my lord. Payment has been made, my lord. And now if lordship comes down to, my lord, page number 44, that payment, credit of the payment was not given, my lord. Totally without application of mine, my lord. The total amount is,
made?
my lord, page number 44. Considering 42 and 41 and 42, my lord, the
41,
payment.
how much payment is made? 3,000 something.
3,602, and thereafter, my lord, in 42, my lord, 6,803 in cash.
9,000 and all.
9,000 on. My lord, 9,000 odd into 2, my lord, under both that.
Yes.
It was not given credit, my lord. Subsequently, my lord, as because these were all uploaded in the additional notices column, my lord, I preferred an appeal before the authorities, my lord.
No, 9,000 and odd into 2, no. 3,000 and 12,000 and odd. 50,000 and odd.
My lord. my lord,
16,000 and odd.
50,000 and odd. My lord, if your lordship matches it with the notice in page number 34 and the so-called notice in page number 44, 34 and 44, my lord, the amount is the same without giving credit to the payment made.
34.
34 and 44. 34 is the pre-so-called notice, my lord.
Yes.
My lord, 34, all the columns matches with the page number 44, which is so-called notice.
Yes.
My lord. Herein after, my lord, I preferred an appeal, my lord. And the appellate order, my lord, the part starts from 116, my lord.
116.
116.
Yes.
My lord, E, from the bottom, my lord, 2 lines, my lord.
Yes.
In respect of ITC found reversible to the tune of 176,62897.38, my lord, IGST, my lord, this 174,45591, and thereafter CGST of 1,86,052 and SGST of the same amount, my lord, as one in GST at 2 a place of supply was not shown, my lord. I am not disputing this amount, my lord. Therefore, my third line, my lord, ITC found reversible in respect of credit note received from the suppliers involving ITC of 174,55,111.81, my lord, IGST of this amount, my lord. Thereafter, my lord, 1. At the outset, I want to note that note here that I am discussing these 2 points together for convenience, as the applicant, either in his appeal application or at the stage of appellate hearing, my lord, always try to mix up these 2 points for reasons best known to them, my lord. But there is no question of mixing up, my lord, as because the so-called notice was very clear, my lord. There is no question, my lord. 2. The applicant has noted some arbitrary and evasive point in his ground of appeal in respect of complaint of hotel services, my lord, availed in the state other than the state of West Bengal, my lord, the purchase of air ticket and mobile phone for which the claim ITC involved, my lord. This is not disputed as because 4,000, my lord. I am not into this, my lord. Thereafter, 3, my lord. In the same arbitrary and evasive manner, the applicant claimed that the ITC found reversible in respect of credit note received from the supplier was added up to the outward liability under IGST head, and the same was paid through Form DRC 3, my lord.
Yes, please proceed.
My lord. My lord, 3, my lord. My lord, I'm once again, my lord, reading it. In the same arbitrary and evasive manner, the applicant claimed that the IGST ITC found reversible in respect of credit note received from the supplier was added up to the outward liability under IGST head, and the same was paid through DRC 3, my lord. Such claim is not only upon utopian in nature, but also could not be sustained by the proper reconciliation statement upon matching of the figure as per the return submitted and the final accounts and supporting documents. My lord, I say here, my lord, pausing a moment, my lord, my return was very clear on this, my lord. He has not considered my return, my lord. My lord, if your lordship.
This would require it because this is a factual.
I am accepting it, Malad.
Before vacation, there are a lot of motion. I think this matter may wait for after vacation. Let us.
Malad, 5 minutes. 5 minutes non-application of mail, I'll prove it. 5 minutes.
You are ready otherwise, Mr. Chakravarti.
Well, let them get an instruction from the department, my lord. It is standard
for 18,000.
My lord, no, 1,74 lakhs, my lord.
No, but you showed payment of 18,000 only as of now.
No, my lord, my 1,74 lakh was added to the output tax, my lord. I'll show it before your lordship that the return is very clear upon this, my lord. They have,
show me that so that
my lord, they have, what is the law, my lord? They have scrutinized my return. Notice was issued. My lord, all the figures ought to have been considered, my lord. If I show before your lordship, my lord, the figures are very clear, my lord, from the record, my lord. I should not have been troubled, my lord.
Where are the figures?
My lord, but I given us the pertinent, my lord. My lord, sheet, my lord. My lord, statement of IGST, ITC on credit note. My lord, as per the scrutiny of return, my lord, page number 34, my lord. In fact, my lord, 39, my lord, if lordship comes, my lord. 39, my lord.
39.
my lord, on the top, my lord, 4C, 4997.41, my lord, and my lord, 4C, and thereafter 4F is 1 crore 74 lakhs, my lord. Was you found it, my lord? My lord, now the statement which I have handed over. The first is credit note is 1744059. That is the figure, my lord, appearing in column number 4F, my lord.
Yes.
My lord, and thereafter, my lord, place of supply appearing in column number 4C, my lord, 4997, 4997. My lord, these two figures, my lord, add up to 174,45,591.74, my lord. My lord, and it matches with the page number, my lord, 34, my lord, of the petition, my lord.
Yes.
My lord. My lord, 474,591.74, my lord, it matches. Thereafter, my column number 2, my lord, as per 3B, my lord. What is my 3B? My lord, page number 73, my lord.
Yes.
My lord, column number 3.1A, my lord, outward tax liability.
Yes.
My lord, outward tax liability, total taxable value is, my lord, 1 crore 36 lakh 07709, my lord. First column, my lord. And my lord, my tax, integrated tax is 1 crore 77 lakhs, my lord. My lord, 1 crore 36 lakh is my output supply, my lord, figure. The tax cannot be the more than the supply figure, my lord. What is, my lord? My lord, I say 1 crore 36 lakhs was my output supply, total output supply. And according to my return, my lord, 1 crore 77 lakh is my integrated tax, my lord. It cannot be, my lord. It is more than 100%. In fact, my lord, more than 129%. Now, my lord, if lordship takes this figure, my lord, this 177,4264, my lord, is my from the reconciliation, my lord, which I filed, my lord. Total IGST liability declared is 177,4264, my lord. The statement, my lord, I have handed over. Thereafter, my lord, less IGST liability declared in GSTN 1, my lord, 130,635, my lord. My lord, in this, my lord, this statement, my lord, page number 2, lordship comes.
This is not there in the writ petition. This document.
My lord, this is as per the portal, my lord. For the convenience, my lord, I have compiled it in a column, my lord.
No, but is this part of the writ petition?
No, my lord.
Because then in that case, they will not be able to know this now.
My lord, this is the summary, my lord, from the generated from the portal. I want to, my lord, emphasis is upon this, my lord, as because he ought to have considered it from the portal, my lord. My lord, why I'll be supplying the further documents, my lord?
The writ court you will have to.
My lord, that is true. That is true, my lord.
By way of the
My lord, here, my lord, total integrated tax is 130,635, my lord. My lord, this is financial year 1819, my lord. From the top, my lord, on the right hand side.
Yes.
1819 and column number 4A, my lord. The total integrated tax is 130,635, my lord. My lord. My lord, now from the page number 1, my lord, if this is deducted, my lord, 176,09629.81. My lord, page number 1. Thereafter, my lord, less ITC reversible, my lord, 174,45,591 is the notice, my lord, from the notice, my lord. Page number 34. My lord, the restitutory part is I have deducted in excess, my lord, 164,038.07. Now, my lord, how do I, my lord, lordship comes down to, my lord, page number 10 of the statement handed over, my lord. Lordship, come, my lord. My lord, from the bottom, my lord, 0.4, my lord. Thereafter, 9A.
Yes.
My lord, my total output tax liability is 178,59,499, my lord.
Yes.
Whereas my output tax, my discharge of the tax is 178,59,499. Whereas my output tax was 1 lakh, my lord, 1,30,365, my lord. In page number, my lord, 2 and of the GST 1, my lord. My tax is 130,635. Whereof, my lord, the detail of payment, my lord, as per page point number 4 is, my lord, 1 crore 78,59,499, my lord. Now, what I have done is I have added my credit note to this output tax payable, my lord. and have discharged it through cash ledger, my lord. Point number, but this 10, my lord. Paid through ITC, my lord, 9731, 369. And thereafter, the last column on the integrated taxes 64, 50, 25, 689.
Let them come with a report then.
My lord.
But after vacation, not this side of the.
But in the meantime, I got some protection, my lord. That's because I've paid the total amount of tax.
These are private, that is not a private view also. Relied on documents, which is not part of the writ petition. My lord knows that if in writ petition, documents are evidence. If that are not part of the writ petition, well, let him put in something. Mr. Charoria is appearing, his client can oppose. So, 10%.
Is this a reasoning, my lord? My lord, they will not apply their mind, my lord, while my lord issuing me a so-called notice, my lord, or a scrutiny of returns.
Very well, Mr. Charoria, since if you had preferred an appeal before the stat, you would have to put in 10%. You put in 10% of the balance.
My lord, it is a question of, my lord, 20 days, my lord. My lord, it is a question of 20 days, my lord. It can be stopped, my lord, as because I have produced, my lord, 1,64,000 extra tax has been paid, my lord.
If this had been on affidavit, I could have done it. You file a supplementary then.
Well, I'll do, my lord. I'll do.
Learned advocate, Mr. Charoria, learned advocate appearing for the Taragil.
The petitioner. The period includes assessment year 13-14. When what happened in this case, when assessment order passed in the year 2016, 11 March 2016. Then we prepared an appeal in 2016, 16th April 2016, my lord. Then, my lord, we made an application for stay on August 16, 2024. The stay was granted in favor of the petitioner, my lord. Then, my lord, they have initiated rectification order. They had also passed. My lord, everything is covered. All of a sudden, my lord, on 3rd of March 2025, they have issued the intimation under section 1245. And we file a response to that notice under section against the notice issued under section 245. They have not considered at all, adjusted the amount with the refund for the period 2024-25. Now, I mean, coming to this before, they have not. There is another issue is there, the interest, they have charged interest of 41 lakhs for the assessment year 13-14. Neither they have issued the notice for the adjustment of 41 lakhs, neither they have considered the AO's comment or my comment, Nothing, my lord has issued passed an order in many cases. Recently, in case of what is Gaurav Enterprise, my learned appeared, Mr. Sharma appeared, and in my case, in my opinion, my case is better than that case. I can place from the records, if my lord requires.
Yes, Mr. Bhattacharya.
Take time for instruction. Fine. I do not want to
When do you want to come back to?
Monday.
Monday. Monday.
22nd. Uh, এটা আটকে দেবেন। Yes.
Great.
This is the same petitioner, Jyoti Tar. This is for financial year 21-22. 2 financial years, your lordship has kept on 17. That was under 74. Here, lordships, a scrutiny notice was issued. Why it is coming? Because lordship, they have issued the last hearing notice, which is scheduled today. So we have responded to them on Saturday that the matter has been upgraded by this court and kindly.
And what is the challenge here?
Challenge, lordships, here 73 RC cancellation, but under 73, but without considering any of my reply. I'll just show 2 documents. Lordship, page 40, they issued me a.
A person who gives a 150 pages reply at the stage of scrutiny. Right, it is not possible. It is not possible. He drags the issue and then comes up with a pre-judge issue. But 150 pages at the scrutiny stage.
I will show, lordship. Let me show them. Lordship.
Is it possible?
What is there in 150 pages? I will show. They will copy that I have to produce. That is, there is no permission to direct. I'll show. Lordship, page 40 was the scrutiny notice issued. Page 41 is the detailed scrutiny. 3 points, lordship, may see. Page 41 is the table.
Yes.
So, tax short paid, ITC availed in excess, ITC found reversible. During the page 48, I give my reply. Lordship, may kindly take page 48, my reply acknowledgement. Page 49, my reply starts. And my reply is up to page 59. 10 pages reply.
The others are document.
Lordship, the e-waybill copies, the bank statement, and that.
Then, Mr. Chakravarti.
I will show.
10 pages are justified.
10 pages reply. And that also in tabular form. Because in scrutiny, I have. No, let me submit, then I will place. Lordship, that's separate cases. Lordship, separate case. Lordship, I will show why I have come to court. I will show why I have come. So I give my reply, lordship. Now, page 296. Show cause. 296 summary lordship, 298, 299, only 2 pages show cause. Maybe lordship is the second volume.
Page 296.
296 is the summary.
Yes.
297 also is the summary lordships. 298 kindly take.
Yes.
So lordship, he records that these are the points. Table, the above mentioned registered taxpayer here during 21 has availed excess ITC which was inadmissible and therefore reversible as per scrutiny communicated under ASMT 10 along with attachments. A detailed reply was submitted. Many points raised in the scrutiny sheet which was sent to ASMT have been explained and reconciled. So tax short paid, ITC availed in excess. He has accepted these 2-3 points. Now lordships, table 4B, second last paragraph of 298, table 4B. Page 298 lordship is there. It starts with table 4B.
Yes.
As per explanation, a few of the non-filers are actually quarterly filers. This is found correct. Further, other non-filers, this is important lordship. Further, other non-filers are part of ab initio cancelled suppliers covered under table 4A. The alleged reversible ITC in respect is therefore a subset of ITC reversible under 4A and is not to be demanded. This too is found correct. After the above mentioned reconciliation, amount payable in this case remains as below. ITC reversible which was wrongly enjoyed by RTP from fraudulent, non-existent suppliers whose registration has been cancelled ab initio. As per table 4A of scrutiny detail, he lists down the supplier name. He quantifies the demand. Page 299. In your reply in ASMT 10, you, the RTP, did not furnish any document whatsoever relating to above mentioned transaction, validating the actual movement of goods for the purported supplies to yourself, and failed to furnish irrefutable documentary evidence in support of claim of having actually received the goods from the suppliers who are actually non-existent and procured registration by fraudulent means only to make fake paper transaction. It is stated here that mere possession of purchase invoice and relevant bank entries do not suffice for claiming ITC in the present case where suppliers had procured registration fraudulently and had merely made paper transactions. Such denial of ITC finds statutory backing from provisions contained in 29(2)(e), section 16(2)(73). It is to be mentioned that mere grant of registration to the errant registered suppliers and filing of returns do not qualify for bona fide entitlement of ITC, and therefore he says, lordship, you have not provided any details of movement of goods, irrefutable documentary evidence. This was his case. Now, what I have provided, he has not recorded. He records he records that in your reply, you did not furnish this document. But what I have furnished, he has not recorded. But that is on record. Lordship, may kindly take one, page 49. I will not take your lordship to those annexures because those are e-way bill copies. Page 49. But my reply has recorded. 49, my reply starts, lordship. First point is not related to this issue. Lordship, then page 51. That is also not related to this issue. 3M. Page 51, 3M. Now, lordship, page 52, 4A. In the show cause, lordship has seen 4A, he has started. 4A, lordship, what I write? It has been stated in the notice ITC of rupees this from vendors whose registration has been cancelled retrospectively. Now, in scrutiny notice, there is no attachment or any record of any inspection of these suppliers. Only a ledger, only a list. These are coming in your 2A retrospective cancellation, so you reverse. Because they say retrospective cancellation means he is non-existent. What I write, lordship, I write that I have filed 3B returns on self-assessment when ITC has been availed based on invoices and also payment has been submitted, relevant extract of 59. Then lordship, the notices say that the transaction is genuine and valid and with due diligence has been performed. The supplier was very much existent at the time of transaction as the tax invoices are in possession, which proves, therefore, it did not signify that any transaction is not taken. Copy of invoices, ledger is produced. I produced all invoice copies with e-way bills. E-way bill has vehicle number, which shows movement, because that is the only document under the schedule which is required for movement of it. Only document under the whole of schedule section 67 deals with the inspection of goods during movement, and the department is empowered to seize to stop my vehicle if they want to verify the goods during the course of it. I produced e-way bill, I produced there my bank payment proof marking each of the ledgers. Then, Lordships, in my reply, I give them screenshot of the GST portal showing the status of the suppliers as return filed for this period. Lordship, under section 16, there are 4 conditions. I should have tax invoice, I should have received the goods, I should have made payment to the supplier, supplier should have paid the tax. 4 conditions to avail IP. I say I have invoiced, I have made the payment to the supplier. GST portal screenshot shows the supplier has paid the tax and I have made the payment to the supplier. Under section 155, the burden of proof is on me.
This is not a case of fraud. This is not a case of fraud. If the supplier has paid the taxes.
The question is whether what is the stage?
No, if see the whatever may be the stage, but this must be given some meaning. If there is because now after the division bench in that case where it is said that pre-show cause notice also you have to consider and then give the
considered that. Why?
no, but this does not show actual consideration. He says we have not furnished.
Lordship, before that, Lordship, may I submit 2-3 points? Before my learned friend will submit, Lordship. 2-3 points. Lordship, Suncraft was dealt in detail by this division bench of our presided by the Chief Justice, and in that Suncraft, detailed guidelines have been laid down by the court as to when can action be taken against me. सर के पास है सकता है. Lordship, may kindly take Lordship paragraph Lordship paragraph 8 in page number 7 of the judgment. Para 9, Lordship. I'll make it short. Para 9, page number 7. Page number is given in the top, Lordship. Para 9. May I place this, Lordship?
Yes, I have.
Lordship. So my exact point is, Lordship, I have burden of proof. 155 is on me. I am not disputing. Now in the show cause, they say no in what is the term they use, Lordship? In the show cause, no irrefutable document evidence. What is that document, Lordship, if that can be given? E-way bill has vehicle detail. It is not their case. What was the inspection done at the supplier end? They have not given me. Whether they have, Lordship, also take 76 months. In fact, Lordship, in November, a detailed judgment, a batch of petitions were disposed by Honorable Kerala High Court on same issue. Following Suncraft in details. Kindly take, Lordship. This was one of the orders I brought, and it was a batch. There were many such orders then passed. Lordship, this order is dated 27th of October. Lordship, may kindly see the observation of this of the Honorable Court, wherein the discussion starts at para number 9, page 7. Internal para 9 of the judgment, Lordship, page 7. I have carefully gone through the records and examined the statutory provisions. While considering the aforesaid question, it is to be noted 16(2)(c) as it stood in the relevant point imposed a condition that ITC under section 61 could be claimed by the purchaser only if the tax charged in respect of supply has been paid to the government, either in cash or through credit. However, the procedure to be followed for realizing the said amount was contemplated under 42. Then 42 is quoted, Lordships. Page number 11, para 10. When coming to subsection 3 of 42, it can be seen there is an obligation imposed upon the authority to issue a notice communicating a discrepancy to both such persons in case of short supply is found. Evidently, before issuing the show cause, no such proceeding has been followed. 42(5) is also relevant in this regard, which could indicate that the amount in respect of any discrepancy which is not rectified by the supplier in his valid return for the month shall be added to the output liability of the recipient. Thus, the consequence
Different because this scrutiny notice also was not given. It appears.
in my case, scrutiny, the chart is only given. There is nothing. In the chart, I will show. Let's say kindly take scrutiny notice once, page 40. What is given to me?
But that you have replied. That
I have given.
therefore that point is not.
No.
Yes,
Lord-
given 150 pages.
No,
If he
Lordship.
had something, it would have been 300 pages.
Lordship.
Well,
Lordship, kindly.
No, 31st December is the last day. Let us pass an order and will not give effect to the order. Minor kindly keep this for him. All motions will be started this matter. Well,
That can be done, Mr.
Lordship, in that case, I will, Lordship may give 3-4 days time for me to file my reply because my reply is not on record yet.
Right. अच्छा दीदी एक जगह এটা লিখে নিন
Sancraft, I have given the Sancraft is that Supreme Court citation also I have.
এটা 2 করে দিন আর এটা 3 তিনটা হ্যাঁ 1 2 3 দেখে পড়ে না থ্যাংক ইউ কাম ব্যাক আফটার রিসেস
I'm for the petitioner. Mr. Sanal is coming, my lord. I've telephoned.
Very
Yes, my lord. Here, my lord, I'm challenging, my lord, the ex parte appellate order and ex parte adjudication order under section 73 and show cause notice. My lord, in the appeal, my lord, they rightly issued notice of hearing and 3 adjournment. I missed, my lord, because I'm senior citizen and dependent on a tax collector communicated on the portal. I missed. But, my lord, importantly, the grounds of appeal, it was not considered. And the allegation against me that the common credit issue, I am the trader and also GTA service provider. So, my lord, GTA service is non-taxable. So, common credit issue not applicable. In this regard, my lord, I have uploaded the
just a minute.
I have uploaded the transport bill. And in the appellate order, they are saying that no documents submitted. So, transport bill is the important. I have submitted attached with the appeal petition. This is the appeal. In the adjudication, my lord, in the show cause notice, it is written, so not applicable personal hearing. And my lord, the second reminder notice issued in the month of February, order passed in the month of April. So in between, my lord, one more opportunity could have granted. That was not given. And main allegation is, my lord, that the common credit issue. On this common credit issue, according to Rule 42, I have calculated and stated in the para 26-27 of the writ petition and paid 4.56 lakh tax before filing of writ petition after filing of the after passing of the appellate order, my lord. That calculation I have made, my lord. Because, my lord, the common credit issue not applicable because I have two nature of business. One is, my lord, industrial switchboard, nut bolt purchase and sell. Those are the taxable. So taxable purchase, taxable sell, ITC I am eligible, no problem. But they are saying, no, your supply is GTA. So GTA is, my lord, those who are receiving the service, they pay the tax under RCM and they get the ITC. But that they are not going on that part. They are saying this is taxable, non-taxable item. So you have to reverse the common credit. So common credit not at all applicable. That I have stated in para 26 and 27 of the writ petition, my lord. And grounds of appeal not considered. So, my lord, your lordship may remand the matter to the appellate authority or, my lord, to the
Which ground has not been considered?
my lord, that main ground, my lord, that the yes, kindly have a look, my lord, appellate order at page 106, my lord. The first, second, third, fourth. With respect to discrepancy serial ITC found. This is the main allegation, my lord. The saying appellant could not produce any document credence against this discrepancy. My lord, kindly have a look at the transportation document at starting page 74. This is a transported. I have attached with the appeal petition. Online portal, it is available. I have personally checked, my lord.
And in the grounds you have mentioned that?
Yes, yes. In the grounds, my lord, in the page 72, my lord, second para. Though it is not properly drafted, but it is clear from the drafting, my lord.
Yes.
72, my lord, second para. ITC found, your lordship got 72. ITC found reversible if able, downloaded such and such, such and such. With due respect, I beg to inform that difference mismatch ITC reversible, credit note received, such and such, such and such. I want to inform you that all credit note adjustment 3B, all ITC availed which are related to taxable goods, comma, exempt supply, GTA service, good transport agency, that not, it is exempted under notification number such and such. So proportionate concept is fatless. And details, my lord, in the writ petition, para 26 and 27, I have dealt, my lord. Kindly have a look, my lord, para 26, my lord. My lord, page 10 of the writ petition.
Page 10.
10, my lord. 26, my lord, that ITC found reversible if availed by your petitioner directed to pay such and such, such and such. ITC found reversible, credit note received such and such, such and such. In that regard, your petitioner stated that all credit notes adjustment 3B, ITC available, which are related to taxable goods at exempt supply, that is not applicable. Transportation service of goods by road, notification number such and such. That notification I am carrying is free from GST service. And
so they have imposed GST service even on those?
No, not imposed. They are saying that common credit issue that I have to revert ITC proportionate to the non-taxable supply. That is I have stated in the replied para 27, my lord. Important, very important. This is the calculation, my lord. Lordship may see, my lord, I have made the calculation here. And accordingly, my lord, after passing of the appellate order, before filing writ petition, I pay 4.56 lakh tax. That challan I have attached, my lord, in the writ petition, my lord. After that, no tax is payable. So, my lord, your lordship may remand to the matter either appellate or.
But I could not understand which point has not been considered.
Yes, my lord. This point, para 27, my lord. May I read, my lord?
Para 27.
Your petitioner states that adjudication authority is taken ITC such and such, such and such, such and such, reversible under T Rule 42. The transport business outward supplied such and such, where outward exempted supply RCM supply or such and such, exempted such and such, RCM such and such. The outward supply of transport charge is provided through inward exempted transport charge showing freight as rupees 724 such and such. So the exempted or RCM service provided through inward exempted service as per serial number 18 and 22 notification number 12 of 2017 central tax are not constitute any liability of reversible of ITC because of any goods or services like tire purchase, spare purchase, repairing vehicle from ITC was claimed are not involved in the said outward exempted or RCM supply. So outward exempt supplies 11.44 plus, then provided through inward exempted supply only 1 crore 44 plus, provided through own vehicle, which liable to be calculation. That is why some tax is payable. Reversible ITC. So
And
one
how has it been dealt with in the appellate order? Show me.
Appellate order, my lord, at page 106, my lord. It was not dealt, my lord. In the second part, my lord, that 106, first, second, third, fourth para, my lord, before the order para, my lord, with respect to discrepancy serial number ITC found reversible if availed. This is this point, my lord. Though, my lord, I should submit that grounds of appeal drafted but not properly drafted, my lord. But issue is there in the grounds of appeal that not dealt. And transportation documents, my lord, I have attached in the my appeal petition, that was not recorded, my lord.
It says appellant could not produce any document of credence.
Yes.
This discrepancy.
But 74.2, my lord, that 74.2 74 to 84, 86, sorry, 88. That document I attached with the appeal petition at the time of filing online appeal. This is online dashboard. This is available, my lord. That is, they not check the portal, my lord.
Yes, Mr. Chakravarti.
Can you remind the matter? I have seen the appellate order. It should have been. They should have given independent observation. But there is no independent observation according. Can you remind the matter?
Where is the adjudicating authority?
And adjudication order, my lord, at page 58, my lord. A personal hearing here, my lord, not given. Kindly have a look, my lord. That order passed in April, page 58, my lord. And my lord, show cause notice at page.
No, 58 is summary order, right? Main order.
Yes, main order is, my lord, main order at page, starting page, my lord, 63. This is also not speaking order, my lord.
And from where do I find that these documents were annexed in the appeal has written?
Yes, yes, yes. It is, my lord. I have attached, my lord. In the portal, it is available, my lord.
No, in the appeal, you have not written anywhere.
No, in the appeal, it is not written, my lord. But in the writ petition, I have written, my lord. Writ petition para I have written.
And what is the meaning of this 72 ITC found reversible if availed? What have you written here? I could not make out.
ITCs?
Page 72.
Oh.
Second paragraph. What do you want to say?
ITC. My lord, the ITC found reversible, this paragraph, my lord.
Yes. What is the meaning of this paragraph?
This paragraph, my lord, according to me, my lord, not properly drafted, but tasked, only tasked. That is why this paragraph.
What is it? That is why I want to understand from you. What does it want to say?
It says, my lord, that GTA service is not under the purview of common credit. So common credit
Where
is,
is common credit ground taken in the appellate order?
my lord, this is common credit allegation because as per the show cause notice it is clear, my lord. Yeah, the show cause
Show me
notice.
that.
Yes, my lord. Show cause notice. My lord, show cause notice starting page 50, but my lord, 52, my lord, kindly have a look. 52, then 53. 52, my lord, major portion part is 22,47,000 and 53 middle portion, my lord.
53.
Middle portion, my lord. That ITC found reversible. Lordship got, my lord?
Yes.
If available, upon scrutiny of the returns furnished by the RTP, it was found that he had availed through 3B excess ITC such and such, IGST such and such, CGST, EGST such and such, out of ITC such and such were found reversible in proportion on the exempt supply.
But
And
where is this expression common credit coming from? You use legal expressions.
no,
What are
the
there?
legal expression is, my lord, the proportion of
So use that
exempt.
expression, because
Yes.
if you use colloquial expressions, I'll not be
Yes,
able to
yes.
understand.
It my mistake, my lord, my mistake.
That is why I wanted to see where
Yes.
are you getting common credit from?
Yes, in a
Now
proportion to credit, reversal of credit.
how is this? How has this been answered then by you?
No, my lord. Appellate in the adjudication, my lord, that notice issued rightly. Thereafter, one reminder notice issued in the month of February. I
Did
means
not
because
file any notice reply. to
no
this
reply filed. Expertise orders. Thereafter, they passed the order in April. So in between, my lord, one more
But
opportunity.
if you also did not file reply,
Yes, yes,
that's
yes,
good.
yes, my lord. And personal hearing, my lord. In the personal hearing, my lord, kindly have a look, my lord. The show cause notice, page number, my lord.
Very
50,
well. Let us not go to that. I'll stick to the appellate order. You explain the thing to me so that I can frame my order.
Yes,
What is
yes,
the
yes.
actual thing? I am still to understand.
And my lord, that point, my lord, para my lord, 27 of the
Yes,
petition.
27.
Here, my lord, I have written, my lord, that explanation that why the tax is payable. And 4.56 lakh I have paid, my lord. That is why, my lord, kindly have it.
Not clear.
And 2829, my lord, that I have relayed the notification that where that GTA is, my lord, non-taxable. That notification I am carrying also. That dealt in para 2829.
I'm still unable to understand
I'm
the
not
problem.
confused, but I got more confused with this paragraph.
Yes, because I am unable to understand the problem. What is the problem? Because your 27 also is not clear.
My lord, simply, my lord, say I have purchased 100 rupees goods, taxable goods. So I sold on 110. So I input credit availed and outward adjusted. But besides that, I have some, say, 200 rupees non-taxable purchase. So here not purchase, here services. GTA is service, my lord. So non-taxable services, my lord, GTA, they are saying their allegation, because their allegation also is not very much
You
clear.
first explain the point. In the meantime, you are going here and there.
No.
You first finish one point, then go to the next point.
Yes, my lord. So, my lord, they are saying that common ITC, they are saying that this ITC, as I have non-taxable sale, So that I have to reverse proportionate ITC that from that ITC. But in my case, that I have purchased taxable goods, sold taxable goods. That ITC what treatment was there. But here, my lord, this proportionate calculation will not applicable in my case because the outward supply is completely non-taxable. But some services like audit fees, security services, that is commonly used. That is why I am using the term common credit. Because some ITC I have taken there, some
Proceed. Don't explain.
thereafter, my lord, that calculation I have made in this paragraph that some tax is payable according to rule.
Whatever was payable, you have paid.
Yeah, I have paid, my lord. That I have paid. This is very
Complicating thing.
yes, complicated.
No, this is not complicated. You have complicated.
Oh, sorry. It is
I have a one pages, my lord. on the
Yes, yes, you have
submission,
given.
my lord. May I read it? 1 second, my lord.
No, you had placed it on the last.
I have placed, my lord.
Yes,
And my lord,
Mr.
the-
Dey's submission was that there were some stickers upon the same being removed. It was found that it is from Bangladesh. That was the.
Page 41, that is the Panchanama proceedings, wherein it is very clear that the produce are of Bangladesh. And they were.
But what is the law? Is it not the law that after a particular period, if you do not do something, then you have to return it? That
No, they are trying to export it. They are trying to export it by misdeclaring that these are produce of.
Mr. Mullah, on which provision of law are you relying? Which
Madam.
provision of the statute?
124, my lord. But
120.
it is very clear from the, my lord,
The show cause notice has not been given to you.
yes, my lord, give me, my lord.
Yes,
But
my lord.
kindly have it. Look at the so-called document, page 78.
Grounds not mentioned. So what is?
Kindly see, page 78.
Page 78.
My lord. So-called 140. Only penalty. No constitutional, my lord, no proposal, my lord, for constitutional, my lord. So what would be the fate of the, my lord, goods which would be peril, my lord, very soon?
No, but where is the provision that if they do not confiscate, they have to release?
Well, what would you, I put one question to you, what would be the fate of that? There was no proposal.
Mr. Day, what is the provision? If there is no confiscation, it has to be released. But that is his submission.
I did not what is that. Goods were seized. Pursuant to such seizure, they had a right for asking provisional release. They exercised that right. Their application for provisional release was considered, appropriate order was passed. So they were given the right to get back those goods on provisional basis upon furnishing of the equipment. Now, Lordship kindly comes to page 52. They have declined to take it.
Page 52.
Well, I have made amendment in the repetition also, my lord.
Just,
Right.
I'll come back to you, Mr. Mal. I'll come back.
Now, the relevant portion is at page 52A.
52A, yes.
Yes. Therefore, in last paragraph. Therefore, in consideration of the above mentioned facts and circumstances, we decline to comply with the said provisional release order dated 10/7/25 as the same is faulty on technical ground. Now, it is one thing to say that the decision is faulty. If the decision is faulty, they can challenge the decision for provisional release on further in appeal. They have not done so. So on one, there are two things by law. There's an order of provisional release asking them to take the goods on provisional basis, to which they have declined to take it, saying that the order is faulty, but they choose not to challenge the said order.
Not order is faulty, my lord. They have even excessive demand.
No, but at page 52A, that is your reply in writing. Page 52A. See last paragraph. We decline to comply with the provisional release order. As the same is faulty on technical ground. So if you yourself have, so you should have challenged the provisional order then.
And the provisional order is at page 48. Pass on their application. It is at page 48.
So this issue has therefore been dealt with.
So
in one way
therefore,
or
he was given the opportunity. He chose not to take it.
So Mullah, if this order is there, rejecting your prayer for release or conditionally accepting it that on your complying with certain conditions they will release. You are not happy with this, you should have challenged this order then. And this order will be assailable in appeal.
My lord, is if the so-called notice does not
my lord, canvass the proposal of confiscation, my lord, what would be the fate of that?
But where is that provision? There is no provision of that nature. So cause notice can be by imposing penalty also.
Yes. Now, Lordship, kindly
My lord, what would be the fate of that right, my lord?
Lordship, kindly.
What is your answer to this question of yours? You don't confiscate. You only impose a penalty. What will happen to
It
the
will
goods?
take time. What would be the fate of
What
that?
will happen to the goods?
Section 124 speaks of two things. One is imposition of penalty. Second is confiscation. I can impose either of it or both.
Very well. But in a situation where you impose penalty and you do not propose confiscation.
For the timing, we have not proposed confiscation, but we have reserved the right to amend our show cause notice. That we can do at the later stage also. Now, Lordship, let us go by what is there on record. On record, we have proposed for penalty, imposition of penalty. Now, Lordship, kindly visualize the situation where ultimately the show cause notice is adjudicated and penalty is imposed upon the exporter. Now, if I release the goods right now at this stage, if a penalty is imposed along with interest, where is the guarantee that he will pay the duty? There is no such guarantee. For that reason only, provisional release order was issued, coupled with a stipulation upon them to secure the duty, which they have not done. And if I seize a good under section 124, I'm under a statutory obligation to release the goods within 6 months' time, provided I don't issue the show cause notice. Now here, I've issued the show cause notice, I have issued the provisional release order on their application, and they have already submitted to my jurisdiction by filing their reply.
What is there in this provisional release order?
Yes. Now, Lordship, kindly come to page 48. Paragraph 6 at page 50. Now, before that, another relevant paragraph is paragraph 3 at page 49. Lordship, may I please paragraph 3?
Yeah, I've read it.
So, the authorities from the very beginning has shown them that the window of relief is an application under provisional release, which they have done. Now, on their application, this order has been passed, which is at the relevant portion is at para 6 at page 50. Certain conditions were imposed, which is automatic when an application for provisional release is considered and order is passed.
Is there any provision that if you do not propose confiscation, then in that case it has to be released unconditional?
No, there is nothing. There is nothing.
Mr. Mullah, where is that provision that if they do not propose confiscation, later on they cannot propose confiscation? Because rice does not have that limited shelf life that it will.
If that is silent in the statute, my lord, the honorable court will
because in the facts of this case where they have
my lord,
they have said we will release on certain conditions. These are the conditions.
In our reply, we told that it is faulty because exorbitant.
In fact, if that is so, then the order for provisional release,
then that has to be challenged.
Ought to have been challenged.
Then this has to be challenged.
But this order is staring at his face.
This is an appealable order, provisional release order. You have to challenge it before the appellate authority.
And Lordship, kindly take the trouble to look into section 110A.
24. If the 103rd was silent.
No, 124 says show cause notice either imposing penalty or stating for asking for stating that they will confiscate. Now, if either of the two has been complied with, show cause notice at this stage cannot be faulted. So show cause notice has been issued saying I will impose penalty. You are aggrieved by the show cause notice. You apply to them, they say, they consider and say, I will provisionally release the goods, provided you comply with 1, 2, 3, 4, whatever conditions you say that you are not happy with the conditions imposed on you. Then in that case, you should have carried this order in appeal before the appellate authority. If you don't challenge this order, then this order stands, it binds you. How can the writ court trample this order? Because today, if I pass an order of release, then in a sense, I will be setting aside this provisional order, which has to be done before the appellate authority. You are getting my point? If today I pass an order of release, if you had come up before the provisional order, then in that case, situation might have been different. But after this provisional order of 10th of July 2025 being passed and you not challenging it, if you approach the writ court, then this writ court will not be able to set aside this order because this has by this time attained finality.
Only, my lord, I have come before lordship's small campus.
I understand, but that campus is closed because of 10th July 2025 order. You see page 48. This is an order directing that release will be done only if this is complied with, and that is on your application for release. You had approached the authority, they have decided this in one way. This becomes appealable. It becomes difficult.
And Lordship, section 110 is stipulated that conditions are to be imposed at the time of provision release application.
My lord, what would you say the 124th, my lord? If the
124th.
proposal is not given in the
Reply to Kudha.
so-called notice, my lord, as per
Proposed notice can be subsequently amended also. That is what is the provision. They have said that.
Last annexure. Please already.
Now they cannot now challenge show cause notice after giving reply.
reply is already given.
Yes. So they cannot because they have submitted.
Unconditional release, court will also not grant.
Because it cannot be granted in view of section 110A. Lordship, kindly see section 110A once. Any goods, documents or things seized or bank account provisionally attached under section 110 may, pending the order of the adjudicating authority, be released to the owner or the bank account holder on taking a bond from him in the proper form with such security and conditions as the adjudicating authority may require. If he is not happy with this order, he has to prefer appeal.
Yes, Mr. Mullah, make up your mind.
Well, I have also replied on the against the so-called notice.
So therefore, Malad, they now cannot challenge the show cause notice. Once they have submitted to
So called notice they are not challenging also. They want release, but in view of the provisional order, it is difficult. Provisional order says that you have to pay that amount of 20 lakh and odd, 20 lakh 5,991.
As per para 6, which is exorbitant to the petitioner.
So why don't you challenge this in appeal? Go before the appellate authority. Go before the appellate authority challenging this. What is the time to challenge?
90 days.
Subject to correction on 60 days or 90 days.
Page, paragraph, sorry, section.
Section
অর্ডারটাকে পাস করে যদি বলতে অর্ডারটা এইখানে
My lord, kindly give liberty to the petitioner.
অর্ডারটাকে পাস
Balance, my lord.
Based on the balance.
প্রিন্সিপাল কমিশনার তো সিস্টেম
Principal Commissioner of
তোমার সিস্টেম বিফোর দ্য সিস্টেম
Principal Commissioner.
129A
Typically passed by principal commissioner of custom. In that case, it will be alive both the
129A
section.
129A
Commissioner, my lord.
appeal to the appellate tribunal.
It will be assessed at.
Yes, that's right.
And where is the time limit?
My lord, 1 minute,
90 days.
90 days. এই তো
Lord, you kindly come to section subsection 3.
30 months. মিনিমাম হচ্ছে 90 ডেজ, তারপরেও কন্ট্রোল করতে পারেন সাফিসিয়েন্ট কোয়ান্টিটি।
Three months.
3 months. Further it can be cornered 8 months.
This writ petition has been filed within time. So the time during which this was pending, if that is excluded, he will be within time before the appellate authority. I will direct that so that this time is excluded.
Application file করতে হবে।
I will direct exclusion of this time during which the writ was pending.
He will get the benefit
He
of.
will get the benefit of the entirety of this. The appeal will be within time. Because July to August to September. So 1 month full and entirety of this will be excluded. The writ petitioner What is your grievance?
My lord, my grievance is that I am preferring this writ application by challenging the order of cancellation of GST registration. The very pecuniary issue is, my lord, I have not able to file 6 consecutive periods returns, my lord. That's why my registration has been cancelled.
There are usual orders passed by this
My
court
lord,
in this
my lord.
matter. You have
On
to
the
copy
same and
that.
similar issues, your lordship, division bench of this honorable court has passed a conditional order to.
দিদি ওটা দিয়ে দিন না একটু।
In the same circumstances, my lord, the division bench has passed a conditional order to comply with this order, and the registration will be revoked by passing the cancellation order.
Where is the order?
I have served.
No.
Oh,
Order of
that
cancellation.
at page 18, your lordship. Page 18 and extra 3. P3.
And why have you come so late?
My lord, the petitioner is old man person. He is not tech savvy, my lord. He is using the keypad phones. He was not able to know that whether the email.
Where have you written that?
That, my lord, at paragraph 10, page 4, your lord.
Page 4.
Page 4, my writ application, paragraph 10.
Very. লিখে নিন দিদি। This writ petition takes exception All right, लिखे नहीं? Yes. You serve a copy of this.
I will serve a copy of
Parties. The parties shall act on the basis of a server copy of the order, and this order shall be communicated to the respondent by the petitioner. Great. Thank you. Original text. Original text. দেখি একটা কিরকম আছে, ছোট হলে করে দেবো কল করবো।
Short matter, delay 35 days, that has not been controlled, the old matter has been dismissed, and bank account has been attached.
Bank. This is Mr. Sanyal. Contesting or not contesting? Total?
No, my lord, 30 days is the controllable period plus
So after that 30.
After that 5 days.
And what is your explanation?
Financial and my lord, even the mother of the signatory was not well.
Mother of the signatory not well is
Not
there is an attachment.
My lord, attachment, madam, what they have done is there are 3 bank accounts. One is an overdraft account. That has been attached after the period to prescribe, after the period to file appeal had expired. But that is an overdraft account. In that they have created a lien of the
Overdraft account, how can they attach? Because that is loan.
They have done a lien on that.
How can you attach? Loan is somebody else's money.
My lord, they have done a lien on the entire amount.
He will be very happy then if his loan is attached and paid by someone else. Very well. Once the appeal is restored, the attachment will go. You can. This writ application mount Yes. Originals. Yes.
And it is, I think, you are. Okay. What notice that?
71. Yes.
Magdal. Well, the problem is this. Four assessment years are involved. I have filed the return as per Act. They did not process it with the plea. Bengaluru is not cooperating with me. Income tax estate. Thus, it became barred by limitation. Well, once barred, cannot be extended. But on the other hand, they were doing for others' years money. They were deducting from my refundable amount 2 crores and odd is refundable to me according to the calculation. Well, they did not. So I came before this honorable court. Honorable Mr. Indiamurthy admitted
What
me.
is that mentioning?
No, early register for this reason, my lord. Now, CBDT has passed an order whereby time frame to make assessment which have become barred has been extended 31st March of this year, next year. My lord, I approached the income tax officer. Now do it. The only thing he said.
We'll take it up. Now, not this time immediately. I cannot upgrade this. It's a hearing matter. Please wait.
The
Yes.
only thing, well, the only thing he is saying matter is sub judice with the court. You obtain order from that to do the assessment within such and such time, and I will do it. That is the only thing, my lord.
I shall look into it. Yes.
Well, the only thing will be item central on any day. Well, otherwise,
So many motions are also there. Let us see.
no, no, only thing, 5 minutes time.
Sir, I will not upgrade it today or tomorrow. I have understood it. I'll look into it. See.
All must look into it. I mean, appearing is good.
Any other mention from your side?
My lord, I'm paying for extension of interim order. The matter is listed in as item number 70.
17.
70.
70.
70.
When
We are
it
for
is
the
expiring?
petitioner. End of December.
Second in.
My lord, I'm mentioning upon affidavit for extension of interim order, my lord.
Item number 1. Worship in matter Agarwal is here. Not Agarwal. Lordship, let the matter be extended to the disposal, your lordship. Honorable Justice, Bharadwaj, in many occasions, extended the order to disposal. What does it matter? There is a jurisdictional error. That the jurisdictional thing of the right. Listen. Whether it is this matter has come up under the heading extension of interim order upon being mentioned therefore, therefore, therefore. Full stop. Heard learned advocates appearing for the respective parties. Full stop. Let the interim order which is subsisting and is to continue till the end of December 2025 is extended till the end of February 2026.
There are many orders, your lordship. There are and special key.
December 2026. Full stop. Mr. Dutt, learned advocate appearing for the respondent income tax authority, seek extension of time to file affidavit in opposition. Full stop. Let such affidavit in opposition be filed within 4 weeks from date. Full stop. reply thereto, comma, if any, comma, be filed within, reply within
2 weeks there, or
thereafter,
2 weeks thereafter,
with
your
which
lordship.
matter for hearing in the combined monthly list of February 2026.
Lordship, in many matters, your lordship, only subject to your correction. It was extended till the end of, till the disposal, your lordship. আর যা হয়েছে আমি তো হুজুরকে বলছি আমি তো kindly speak.
My lord, I am appearing in 1 to 8, my lord, for extents.
Very well, you give your note. End of it.
Deeply obliged.
Same matter. Affidavit. So in 2 you will seek extension. Same order for it. 2 এর 1 এর order টাই 2 এও same affidavit extension ওই যা আছে। Division bench has not yet decided this job for.
Lord, I am filing with the opposition or copy has been filed.
ওই সেম হবে শুধু affidavit in opposition টা চেঞ্জ হয়ে যাবে টাইমটা হবে না affidavit in opposition filed on behalf of the respondent revenue authority is taken on record. They have filed a reply. You have prepared your reply.
No, I haven't filed it.
Time is pressed for on behalf of the petitioner to file affidavit in reply to the affidavit in opposition filed on behalf of the respondent revenue authority. Full stop. Let such affidavit in reply be filed within
4 weeks, your lordship. I don't have a copy.
weeks after reopening of this court, after the Xmas vacation. Full stop. ওই সেম লিস্টিং এর সেম থাকবে মান্থলি লিস্ট অফ ফেব্রুয়ারি করবে ওটা আগেরটা আমাদের ফেব্রুয়ারি ছিল তো হ্যাঁ এন্ট্রি মডেল এক্সটেনশন বলে দিচ্ছি এটা সেমই থাকে শুধু অ্যাফিডেভিটটা চেঞ্জ এন্ট্রি মডেল সব সেম টিল দি এন্ড অফ ফেব্রুয়ারি
I am afraid of item number 4.
রিপ্লাই
After 2 weeks of the vacation.
দাদা ওই তিনের মতন 4 হয়ে যাবে সেম ওই অ্যাফিডেভিট এখন ফাইল করলে ঠিক আছে একটু দেখে নেবেন কারণ হ্যাঁ ফাইল করবে এটা কারণ আগের গুলোতে ফাইল হয়নি যেগুলো টাইম চেয়েছিল এখানে অ্যাফিডেভিট ইন অপোজিশনের টাইম হবে না রিপ্লাইয়ের টাইম হবে অ্যাফিডেভিট ইন অপোজিশন ফাইল টেকেন অন রিপোর্ট
Number 5. This matter is I am still awaiting one is the senior to be appointed so that it is great. The senior filing.
So same order as one. Same order as one. Same as one. এখানে দেখে নেবেন আমি কোথাও অ্যাপিয়ার করতে পারবো I have not appeared in this. Please take that. দেখে দিই আমাকে ফাইলটাও দিয়ে দিন কারণ এরকম ভুলভাল হয়ে গেলে তখন ঝামেলা আবার আমার টু বি মেনশনড এনে এই অর্ডার গুলো না একটু সবকটা দেখে নেবে দেখে নেবে কোনো সাথে যদি অ্যাপিয়ার করে থাকি তাহলে সই করবো না ওটা আবার মেনশন দিয়ে রিকল করি সেম সেম
My lord, my lord, Mr. Lahiri and Pandit have been engaged, my lord, in the change in the panel. So, and my lord, maybe, maybe we could hand over the copies of the petition once, so that would expedite the process.
That is, brother. You asked him, this strategy is very generous.
My lord, kindly gives us some extra time for filing the application.
4 weeks. 4 weeks is enough. 4 weeks. ওই সেম ওয়ানের মতো ওয়ানের এটাও দেখে নিন আমি অ্যাপিয়ার করিছি কিনা করি হ্যাভেন
Item number 9. Full access for under item number 9.
If I may briefly just recapitulate your lordship this matter. There was show cause notice issued on one point, decision on other point. Yes, your lordship, and besides that, your lordship, the cardinal rule for initiating reassessment proceedings is that there should be information in the possession of the department, that income chargeable to taxes escape assessment, and that there should be a nexus between that information in the possession and escapement of income. But in my humble submission, even that mandatory and necessary nexus, which is a jurisdictional requirement, even that is absent, because your lordship, in the entire material, there is no reference to the petitioner, your lordship. That whether it be the report of the investigation wing, the statement, there is absolutely no name, no reference to the petitioner, no link has been established that it is the petitioner's income which is escape assessment. Yes, Sharma.
On the panel, when the notice is issued by the officer, what the requirement is there, he has the reason to believe. It is not that it is established that something has happened. That is not requirement of the law. On the last hearing, question was written by matter. That the amount was received by the blind children, but in 140, we had 3 orders. It was found that amount was received from today. Because it is in the notice, the information which was provided specifically to not present that the amount was received from today. But when it is this, the other documents apply to that from that account, there clearly makes sense. The amount was from the bank and the amount was from the bank. Is
7.
So where is it? There is within the realized general interest happened. 1,961,000. This is the now madam and some page 158.
Yes.
These are the documents which were supplied to us. There, madam, on the top of the table, details of large marketing revenue. So this is the relevant financial year 1890, 19. And the 23rd go. Barman Lorry and Company. The name of the there on the right hand side, Google Insurance Broker Limited. 1 crore 2,41,000 people. So this is from next. Second line number, Barman Lorry Company, no intermediary. So this is the amount directly reflect from And one process like was true. So now the assessing officer has different and this information was provided to the there's a lot of methods substitute of reason to do not be made. That is that's settled. That is settled. Here the contention of officer that there is no sufficient.
No, his contention was so-called on one ground, decision on another ground.
This is the norm. Here Malak we have permitted inside 148. There is the assessing of officer blindly come to a conclusion on the basis of any report. So that is not a point, it is not mandatory. Or that there is 148 two processes have to. So that after receipt of information, the assessing officer will inquire to the matter or come to the promoter in a tentative country. That whether is to be relation on only that. After the proceeding, if it is in my opinion, it is a fifth case to reopen on after taking approval from the specific he will reopen. Now, in that reopening proceeding, the assessor will get all the opportunities. And all the documented materials can be examined. At this stage, it is not that all the evidence will be taken. There is one judgment matter has come up when you see that challenge of a category is noting that not be here the subject matter of the deferred. Again, that order, the assessee will be proceeded. Let him clear the hearing. Yes, para 14. Secondly, this is also no longer in the realm of doubt that a local fishing plan and strategy or strategy cannot be made the subject matter of challenge digitally. And now, the order of the Supreme Court, thereby, I could get in mind. Nice. The using minor, figure is at 49,000. It is better law that sufficiency or adequacy of the receipt for the issuance of the notice for removing of the assessment is not required to be gone into at this stage of the review. It can never be the state that the final outcome of the proceeding has died and by the authority by doing a notice for it. Yes. But the final is 58. But
So may I deal with the cases and then also not come to the.
No, first the fact.
My lord. My lord, may first take the page 87, which is the principal page. Or my lord, may first take the notice itself. And it starts at page 86. Where it says that whereas I have information which suggests that income chargeable to tax is escape assessment within the meaning of section 147. Information is in accordance with the risk management strategy formulated in this regard. The information is enclosed along with the notice. Now, what is the enclosure I get? Well, the annexure at page 87 is a gist of his analysis or the reason to believe why proceedings are to be initiated. My lord, what is the information or the reason given by him? It says the information contains that your company has made transactions with the following insurance companies, not an intermediary. It has made transactions. What transactions are also not disclosed? Transactions with the following insurance companies during the year under consideration, which is not in accordance with the provisions of IRDAI. Company through which transaction was made, Reliance General Insurance Company, 1 crore 9 lakh. Thereafter, it says, Your Lordship, the foregoing information suggests that income chargeable to tax is escape assessment in the case for the relevant assessment year. And thereafter, he says that you are supposed to answer. So, my lord, his case, as per the principal reason given to me, is that I have transaction with Reliance General Insurance Company, which is contrary to the norms of IRDAI. And he's given a figure. Thereafter, Your Lordship, is the case-related information detail, which is uploaded by the investigation wing, my lord, which is at page 89. My lord, this case-related information detail, it says, my lord, if my lord may see the middle of the paragraph, middle of the page, information details. My lord, source PAN and source PAN name, Reliance General Insurance Company Limited. Thereafter, my lord, under specific documents, no documents, no data available. Thereafter, Your Lordship, he refers to general documents. There he refers to Reliance General Insurance Company complete data. So, my lord, he basically relies on the entire whatever data was found at the time of search at whoever's premises, that Reliance or that other group, whatever they found, that entire information has been considered without drawing any analysis, without making any investigation, which is a jurisdictional requirement. So that, my lord, I have sufficient decisions to support my case. Thereafter, my lord, may take the dissemination report at page 91. This is the other information that he's relying on the entire length and breadth of other information. My lord, he's referring to search and seizure on middle layer business entities, namely Wings Brand Group and Ajay Mehta Group. And thereafter, my lord, various insurance companies are named, etc. My name is not there in this investigation report. Now, my lord, when the investigation report, because my lord, all the subsequent data is all just a fallout of this investigation report. The investigation report does not name me. Thereafter, my lord, at page number 100 is one chapter dedicated from that investigation report to Reliance General Insurance Company. My lord, that particular chapter does not contain my name. Thereafter, Your Lordship, he refers to various statements given by various individuals belonging to Reliance General Insurance at page 128. But those statements don't mention my name anywhere. Now, my lord, he gets hold of the department because, my lord, they have conducted search. So they will get all the details, all ledger, all accounts. It doesn't mean every single person who's transacted with Reliance is someone who's entered into a fraudulent transaction. Now, my lord, may kindly take page 154 and 158, Your Lordship. Now, page 154 is where that ledger starts or the details start. My lord, may see what is the heading of that page. Reliance General Insurance Company Limited. And then it talks about my page 154. It's the same as 158, Your Lordship. 158 is identical. If my lord may kindly take even page 158, the very top of the page, it says Reliance General Insurance Company Limited. So this is data of Reliance General Insurance Company Limited. And thereafter it says details of large marketing vendors. I am a vendor of Reliance General Insurance Company, Your Lordship. And even the table, it says marketing vendor, my name, name of insurance intermediary. That is the name given of Prudent. He is just an intermediary. There is no allegation, no nothing written that I have received money or I've given money to Prudent. In fact, it is also my case, I've never given exchange money with Prudent at all. But where does the information say that I've received money or I've given money to Prudent? It doesn't, it simply says who's the intermediary involved. And that intermediary's purpose, my lord, because after I got the order, I've given a copy of that invoice also. He is only raising invoices on behalf of Reliance General Insurance. My payments are being made directly to Reliance.
Reply on this point, to 140
My lord, to this notice, my lord, I filed 2 replies. My lord, I'll show my lord. My lord, my first reply, my lord, may kindly take it at page 193. Because my lord, he gives me a reply to my notices also. But may kindly take page 193. My lord, this is my first reply dated 9th April 2025. My lord, here, my lord, at the beginning, I say that I'm a Government of India enterprise. And thereafter, your lordship, I give the nature of my transaction to my understanding. I say that Balmer Lorry has facilitated air travel insurance for its customers under an empaneled scheme through Reliance General Insurance Company, covering both domestic and international travel. All insurance policies are being directly issued by Reliance General Insurance to the customers. Furthermore, Balmer Lorry has successfully settled the corresponding insurance premium payment directly with Reliance General Insurance Company. And thereafter, at the next page, I give them the details of all the payments made, because I don't know what the nature of transactions are. So first I give him all the details of payments made. Details of payments made to Reliance General Insurance Company, details of payment details including UTR and sample policy issued to customers. So my lord, I first give him, and what do I annex along with it is also, my lord, a copy of the nil certificate issued by CAG. My lord, may kindly take page 196. These are this is the detail I've provided to him. And page 198, my lord, is a sample insurance policy. My lord, that is also significant because my lord may kindly take that policy once. I previously shown my lord. At page 198, my lord will see at the top left-hand corner, name of proposer, Balmer Lorry Limited. Name, Souvik Bhattacharya, nominee, name, legal. This policy is directly issued in the name of the policy holder. I am just a proposer. So I've given him all these details, your lordship. Thereafter, your lordship, I receive one notice from him. My lord will kindly take page 223. At 224, your lordship. At page 224, your lordship, please. So there was a change in incumbency in the middle, your lordship. He says, please refer to your reply dated 9th April 2025, submitted in response. Your reply does not correlate to the notice and information shared with you. Therefore, information is again shared with you and you are requested to submit your reply within the date mentioned in the notice. So he's not satisfied with my reply. So he tells me that he says it doesn't correlate. He's referring to my reply, says it doesn't correlate. So I understand that he's therefore asking for my details of the receipts from Reliance General Insurance. My lord, may take the next page at page 225. This is my second reply. Again, my lord, at the bottom of the page, I've explained the nature of the transaction, my lord. Page 225, your lordship. My lord, I say that the assessee is a public sector undertaking engaged in providing air travel services as a part of value-added services. The assessee facilitates the provision of travel insurance to its customers through an empaneled insurer, Reliance General Insurance Company. The insurance policies were issued directly by RGI to the end customers. The assessee acted solely as a facilitator in the arrangement. It did not underwrite or issue the policies. All the insurance premium amounts were collected by the assessee on behalf of RGI and subsequently remitted in full to the insurer. Additionally, the assessee permitted RGI to display its promotional banners. The assessee also has, if I may recollect, I had mentioned that the assessee had hoardings. It allowed Reliance to put up its advertisements on certain hoardings, whereafter, my lord, it has also received payments on this regard. And my lord, in support of the same, my lord, I have provided all the details at page 229 and page 230, my lord. I made copy of the sample invoices, in fact, all the invoices starting from page 231 onwards, which goes up to all the way up to page 273. I've provided all the details. Now, he doesn't say what the nature of the transaction is. He's the only place where this prudent is mentioned is as if he's just an intermediary in the list of vendors. But there is no rational person will be able to draw a link on this basis. And my lord, that sufficiency of the reasons, my lord, I'll to an authority right now, my lord. There is a decision of the Honorable Supreme Court, which is a landmark decision, still holds the field, followed by various high courts, including our Honorable Division Bench from time to time, that though the sufficiency of the material cannot be gone into, but it is not each and every material, howsoever vague, that can be regarded as information. A nexus has to be established, and this was a decision rendered by the Honorable Supreme Court, confirming a decision of a full bench of our Honorable High Court arising from writ proceedings. A writ appeal order was confirmed by our Honorable High Court. Now, my lord may kindly take his order. My lord. Yes, 679. My lord. And wait. At page, his findings start, my lord, from page 282. And my lord may kindly take page 283, my lord, the last paragraph. My lord, first he says, as per information uploaded by ACIT DCIT Central Circle 53 Mumbai, assessee company received rupees 7 lakh as commission directly from Reliance General Insurance Company. Further received rupees 1 crore 2 lakhs 41,800 through an intermediary, namely Prudent Insurance Broker Private Limited. This is a, if I may submit, this is a false allegation. There is no money which I have received. Thereafter, my lord, it says, however, on perusal of the submissions filed and the documents furnished in the course of the proceedings under section 148A, it has only shown the receipt from Reliance General Insurance Company totaling to such and such. However, no detail has been furnished with respect to receipts of rupees 1 crore 2 lakhs. He's constantly making the allegation. The onus and under section 148, my lord, is first on the department to show that there is material, that income chargeable to tax escape assessment. Even now, the provision mandates this requirement, and I can even show it from the sections that it is necessary for the department to provide me with the information in their possession which suggests that income chargeable to tax has escaped assessment. There is no bank account reference. There is no reference to any materials. My lord may then take his conclusion, your lordship, at same page, my lord, para 6.3. Accordingly, in the present, I am satisfied there is unaccounted receipt of rupees 1 crore 2 lakhs 41,800, which is found to have escaped assessment as per the provisions of the Act. Now, his case all along was Reliance. Suddenly, it becomes Prudent. He's only mentioning him as an intermediary. And my lord, there is a CBDT circular, which my lord, in the earlier decision which I've given, my lord, it says that CBDT itself has acknowledged that department has been issuing 148 notices by simply mechanically relying on any data uploaded by the investigation wing. It in fact mandates that they are supposed to apply their mind to it. But I mean, first, it's my lord, if I may first go to the decision of Lakshmani Naval Das, which is the landmark Supreme Court decision, which still holds the field, madam. And then I will show how my facts are on so much better footing. My lord, if I may take my lord first to page 446, my lord, because the facts have been very succinctly put as to what was the nature of the transaction and the allegation there, my lord. At page 446, and from the second line, it says, the expression reason to believe does not mean a purely subjective satisfaction on the part of the income tax officer. The reason must be held in good faith. It cannot be a merely pretense. It is open to the court to examine whether the reasons for the formation of belief have a rational connection with or a relevant bearing on the formation of the belief and are not extraneous or irrelevant for the purpose of the section. To this limited extent, the action of income tax officer in starting proceedings in respect of income escaping assessment is open to challenge in a court of law. Thereafter, my lord, it refers to a decision of the Honorable Supreme Court. Thereafter, next paragraph, my lord. Keeping the above principles in view, we may now take our turn. We now turn our attention to the facts of the present case. Two grounds were mentioned in the report made by the income tax officer for reopening the assessment of the assessee respondent with a view to show that income had been under assessed because of his failure to disclose fully and truly material facts necessary for assessment. One was Mohan Singh Kanhaiya Lal was shown to be one of the creditors of the FSC, had since confessed that he was doing only name lending. The other ground was that Narayan Singh, such and such person, whose names too were mentioned in the list of the creditors of the FSC, were known name lenders. So far as here, it is a case where they've actually done transactions with these name lenders as the FSC. So far as the second ground is concerned, neither the majority of the judges of the High Court nor the learned judge who was in the minority relied upon the ground. Regarding this ground, the learned judge who was in minority observed that no basis has been indicated as to how it became known that those creditors were known name lenders when it was known. The majority, while not relying upon that ground, has placed reliance upon the case of Chugmal Rajpal. Thereafter, that the extract of the decision is given. Now, my lord, after considering these facts, if I may now draw my lord's attention to page 447. At page 447, at the middle of the paragraph, reference to the names of Narayan Singh, Nandlal, D.K. Narayan Das, Bhagwan Das, Srichand, etc. in the report of income tax officer to the Commissioner of Income Tax in the instance case does not stand on a better footing than the reference to the three names in the report made by the Income Tax Office in the case of Chugmal Rajpal. We would therefore hold that the second ground mentioned by the Income Tax Officer, that is reference to the names of such and such, could not have led to the formation of the belief that income of the respondent is necessarily chargeable to tax and escape assessment for that year because of failure or omission on the part of the assessee to disclose truly and fully all material facts. However, thereafter, it goes, the Honorable Court discusses the next paragraph, my lord. We may now deal with the first ground mentioned in the report of the Income Tax Officer to the Commissioner of Income Tax. This ground relates to Mohan Singh Kanhaiya Lal, against whose name there was an entry about the payment of rupees 74 and 3 annas as interest in the books of the FSC, having made a confession that he was only doing name lending. There is nothing to show that the above concession related to the loan to the assessee and not to someone else. Much less to the loan of rupees 2,500, which was shown to have been advanced by that person to the assessee respondent. But the Honorable Supreme Court is saying that the person may have confessed that he is a money lender, but there is no name taken of the petition of the FSC therein. And my lord, after that, my lord, the principle that was laid down by the Honorable Court, my lord, is at the next page at page 448. Now, this is the portion that has been relied upon by various high courts. At the first new paragraph at page 448. As stated earlier, the reasons for formation of belief must have a rational connection with or relevant bearing on the formation of beliefs. Rational connection postulates that there must be some direct nexus or live link between the material coming to the notice of the income tax officer and formation of his belief that there has been escapement of the income of the assessee.
At the same time, we have to bear in mind.
Yes, Your Honor.
It is not any and every material, howsoever big and indefinite or distant or remote.
Then it also goes on to say that the fact that definite information has been removed, even that matter does not change the nature of the law, Your Lordship. And my lord may even take the next paragraph, my lord.
I have read it.
So, my lord, although the sufficiency of the material cannot be gone into, it's a given. But my lord, that nexus has to be established. And my lord, I will now demonstrate there are various decisions. I will demonstrate, my lord, that my case is not only on a much better footing, but there is no nexus that has been established. No rational person. But another, my lord, some decisions, Your Lordship.
I will touch up other matters also. I have heard when should I keep it close? How long will you take? 10-15 minutes?
But maximum 20 minutes. 15 minutes. 15 minutes. 15 minutes. Some decisions, my lord. And also the decisions of my learned friend.
When can you come?
Tomorrow is my lord is better thinking. Or day after.
Day after.
Right.
Heard Mr. Jhunjhunwala, learned advocate, appearing for the petitioner.
And for the petitioner. Your Lordship, Mrs. Manushi Mukherjee, she was here, Your Lordship. Please. Your Lordship, in this matter, show cause was issued. Your Lordship, show cause, if Your Lordship would take in volume 1, page 61, Your Lordship.
Volume 1,
Page 61, Your Lordship.
61.
Your Lordship. So, Your Lordship, in this show cause, Your Lordship will find that this is a case of overvaluation of export cargo. Your Lordship, show cause is at page 61. Your Lordship, the petitioner duly filed the reply. This was a containerized cargo, export of some drink, which was found to be overvalued, Your Lordship. And the petitioner was the noticee number 3, Your Lordship, the custom broker. So, Your Lordship, the petitioner was also issued the show cause. The petitioner duly replied. The reply is at page 168, Your Lordship, volume 2. Your Lordship would kindly take up page 173, Your Lordship. The reply starts at page 168.
You are challenging a show cause.
No, Your Lordship, I'm challenging the adjudication order on the ground on threefold points, Your Lordship. The judgment which I cited in my reply to show cause notice, which is mentioned at page 174, showing that in case of overvaluation, custom broker has no role, so no penalty under 114 could be imposed. Those judgments have not been considered, Your Lordship. I have, Your Lordship, if Your Lordship kindly take page 174, I have listed the 7 judgments, Your Lordship, to show that valuation is outside the domain of a custom broker. It is on the basis of the documents provided by the party that he files the shipping bill. Your Lordship, this was a containerized cargo. I'm just handing over the first judgment which I had cited, Your Lordship, to show that this point was raised in my reply but never considered in the adjudication order. May I hand over a copy of this?
Yes.
Your Lordship, kindly take the third page of this judgment. It is a tribunal judgment. However, it was binding on the adjudicating authorities. Your Lordship, third page, last few lines, second last paragraph, last 3 lines. Your Lordship, it is not the job of the CHA to compare the invoice price with the market price of the identical goods for the purpose of checking the correctness of the value declared in the export document. It is up to the exporter to ensure the correctness.
This is the only ground on which you have been.
Your Lordship, I have 3 grounds. This is the first ground, Your Lordship.
No, only ground on which the adjudicating authority has held against you.
Your Lordship, the only case in this matter is overvaluation of export cargo. And Your Lordship, the second, if Your Lordship now next paragraph, next page in the written notes, I will just finish with the written notes. Written submission at page 175, Your Lordship, I have cited judgments to show that in case of misdeclaration, suspicion cannot take the place of proof. Mere suspicion that custom broker may be involved should not be a ground for indicting me unless there is a specific evidence. So, Your Lordship, this was my written note, the written submission. Now, Your Lordship, the order in original. Your Lordship,
Where did you say that?
page 175, Your Lordship, paragraph 15. There is not a single iota of evidence as a consequence whereof it appeared that the said noticee had aided or abetted the. Your Lordship.
Yes.
Now, Your Lordship, coming to the order impugned. Order impugned starts at page 178. Your Lordship, discussion and finding at page 202 it starts, but against the petitioner, it is at page 207 and 208. Your Lordship. Your Lordship, in 207, para 34 is summarizing the
allegation against me in the show cause.
Yes.
In paragraph 34.1, Your Lordship, just want to emphasize on the last two lines. Your Lordship, here I have said that I was given all the document, I was authorized, and
The two case laws and request
yes,
for withdrawal.
Your Lordship, this is how he has got rid of the judgment cited by me without dealing with it. On this, Your Lordship, I am citing a division bench judgment of our High Court, Your Lordship. Your Lordship, the judgment in the case of RT Overseas, Your Lordship, paragraph 1 and 2, Your Lordship, that it is the obligation to deal with the judgment and he cannot just get rid of the judgment by saying it is not relevant. In this case, he has not even done that, Your Lordship. And Your Lordship, this is the first point, Your Lordship. The second point, in paragraph 3.2, he said that I appeared in hearing and reiterated. Paragraph 3.3, Your Lordship, 34.3, Your Lordship. This is again my submission in 108 statement. If Your Lordship take page 208, Your Lordship, till the middle of ninth line is my submission, which was recorded by them. Then, Your Lordship, there is a finding that therefore it is evident that the custom broker had made no effort to meet the exporter in person nor physically verified his firm address. So, Your Lordship, this is not an obligation. Your Lordship, remember that I had shown that under the regulation I am to check the documents and that is enough. At page 208, Your Lordship, first paragraph in the Your Lordship, I will regulation, custom broker licensee regulation, Your Lordship. Your Lordship, regulation N 10N. May I hand over, Your Lordship? I have it, Your Lordship. May I just hand over, Your Lordship? Your Lordship, regulation 10N. Custom brokers licensing regulation. Regulation 10N. N, Your Lordship. Verify the correctness of the exporter code, good and service tax identification number, identity of his client, and functioning of his client at the declared address by using reliable, independent, authentic documents, data, or information. There is no obligation to physically verify. On that point, Your Lordship, there is also a division bench judgment of our High Court, Your Lordship. Please stand in. Your Lordship, here it has been observed that it will, at page 5, second paragraph, it will be extremely difficult, if not totally impossible, for the custom broker to physically visit the premises of each of its clients for verification. And Your Lordship, there is no such obligation. This finding is there. And the third point is, Your Lordship, this judgment. Coming back to the, Your Lordship, order impugned. Your Lordship, then there is the finding is when the declared value of goods is so and there are huge export benefits and input tax credit involved, it is difficult to digest that the custom broker would not take the minimum steps to know the exporter and just rely on third parties to facilitate fraudulent exports. Therefore, the culpability of the custom broker in the case of grossly overvalued export attempt cannot be ruled out. So, Your Lordship, the words like difficult to digest, cannot be ruled out, shows that the finding is based on surmises and conjectures. There is no positive evidence against me. Therefore, holds that the custom broker is indeed involved in the attempt to fraudulently export the grossly overvalued goods. And for this act or omission. So, Your Lordship, there is no act or omission specifically mentioned. Only surmises and conjectures, difficult to digest, cannot be ruled out. This is the basis, Your Lordship, for imposing a penalty of 50 lakhs. Your Lordship, this is my comment.
Yes, yes.
First of all, Miller, Miller can come to somebody has acted. Here's food. That is not a satisfactory answer. It's easy to show. Right, so that how can we have power that in the photo and you have that we actually have a actually has the access from which we have obtained body places that are some and shown that some way that some way have so that
Take me there.
One is one.
Yes.
No contact, no even the proprietor is happy or the farm is he told about but completely damage is so but to the that is also national standard another level is this is necessary many years ago, I have some which comes out in the of building over things are controlled. No the topic and community together at the end of the
Your Lordship, yeah. Deal means remuneration here, Your Lordship. That his remuneration was 2,000 rupees for the services, filing the shipping bill. Your Lordship, custom broker works for a service charge, Your Lordship. Authorization is from the importer, Your Lordship. The point two. Authorization, Your Lordship, point number 2 is from the importer.
Yes. Yes.
He is not denied, Your Lordship. I'm very sorry to say, Your Lordship, my learned friend is picking and choosing the paragraph, not reading the whole evidence. Your Lordship would kindly take page 188, Your Lordship. I'm very sorry, Your Lordship, I should not say this. Your Lordship, 188, Your Lordship, my statement, Hariom Mishra was confronted because my statement was matching with the statement of other three persons examined. Your Lordship, please see paragraph 2.17 at page 188. Since the custom broker, the person who arranged the transportation of the said container and also the manager of the warehouse from where the container was stuffed and later on moved to the CFS, all mentioned the name of Sri Hariom Mishra, alias Pradeep Mishra, as the person associated with the export consignment. One more statement of Sri Hariom Mishra was recorded under 108 of the Customs Act on 26/11/2024, wherein he inter alia stated. Now, Your Lordship, the first paragraph makes it clear. He has seen and signed the copies of the statement Sri Sudipto Bose, custom broker, of Bose Enterprise, and admits the fact that he had given all documents of Sri Subir Bose employee, given all documents. It should be two. Sri Subir Ghosh, employee of MS Bose Enterprise, after receiving the documents on WhatsApp from Sri Rohit. So, Your Lordship, he admits that he has given me the documents. And Your Lordship, he introduced himself as the dealing hand of the exporter, Your Lordship. There was no reason for me to doubt because he had issued an authorization in my favor. So, Your Lordship, he was confronted with my statement. Since my statement was matching with the statement of three other persons, and then, Your Lordship, when he was confronted, he admitted that he had handed over the documents.
And who had given the authorization?
Your Lordship, the exporter, Your Lordship.
Exporter had
He
given in whose name?
In my favor, Your Lordship, because he was acting as the agent of the exporter, dealing hand of the exporter. So, exporters, all documents, export documents, shipping bill, Your Lordship, foreign exchange management declaration, bank declaration, all are of the exporter, provided by this person to me, Your Lordship, as the dealing hand of the exporter. Exporter is a Ludhiana-based person. Since he has issued an authorization in my favor, I had no reason to doubt the correctness here. That is the case, Your Lordship.
Authorization in your favor was by the
Exporter, Your Lordship.
Then why did this person come in between?
Because the exporter is a Ludhiana-based person, so this person was his dealing hand in Kolkata, Your
So
Lordship.
how did you believe this person to be the
Because, Your
intermediary or the person
Your
acting on
Lordship,
behalf?
because he has given me all the documents of the exporter, Your Lordship, including an authorization of the exporter. Your Lordship, that is my statement. Because, Your Lordship,
Authorization was not given directly. That was also to this person.
all documents were provided by this person only, Your Lordship. These, Your Lordship,
No, but
including
how do you believe this? That somebody, between Mr. X and Y, X is acting on behalf of Y,
Your
but X has never met Y. X is acting on behalf of Y at the behest of D.
Your Lordship, we come to know, we believe that X, since X has all the documents, which is, Your Lordship, including government-related foreign exchange management declaration, which the exporter has to make, that he is sending the right goods, right valuation under
How
section.
did you exercise your due diligence then? How did you check out?
Your Lordship,
The documents which were supplied in your name to D by X. How did Y come to know that those documents were all in order?
Your Lordship, from the government,
They did not have occasion to meet X. That is
10, that's why, Your Lordship, I cited 10A, that I am supposed to check the KYC documents, Your Lordship. The KYC documents, Your Lordship, here in paragraph 2 I have said, He provided all the KYC documents such as authorization letter, customer information sheet, signature verified by bank, cancel check in the name of KSH International, PAN card of Sahil proprietor, GST registration certificate to his office, as well as the export documents, Your Lordship. After scrutiny of documents, he collected invoice from packing list, other relevant documents from Hariom Mishra. And Your Lordship, he has also verified them. Point 6. He had verified the IEC from DGFT website at page 181, Your Lordship, which my learned friend was placing. He had point number 6, Your Lordship, he had verified the IEC, the import-export certificate from the DGFT website, Director General of Foreign Trade website, verified the GISTN from the GST website. Bank details provided by exporter were itself verified by bank. And there is no requirement and Your Lordship possibility of physical verification by visiting the exporter. Your Lordship, that judgment I have Sun Glory and 10N of the regulation. That is not my job, Your Lordship. Due diligence is from documents, Your Lordship, which was done. Your Lordship, I have taken a preliminary point that the judgment which I had cited was not considered, and the finding is surmises and conjecture, and Your Lordship, an obligation that physical verification is not cast upon me by the regulation. In any event, Your Lordship, here the penalty is under the Customs Act 114, which says act or omission. So, Your Lordship, they cannot improve the judgment. Today, by citing the entire regulation.
Tomorrow will be difficult. Let's have it on Thursday. Thursday, any problem?
No problem, Your Lordship.
18. Third, Mr. G. Learned Advocate appearing for the petitioner and Mr. Mukherjee Learned Advocate appearing for the respondent.
Yeah. If I may recapitulate, we have challenged the imposition, Mr. Sanya. We have to reply. We have challenged the imposition of penalty, and we have not received even the show cause notice. We have just received the third page of the adjudication order, and Your Lordship.
Mr. Bhattacharya was appearing.
Mr. Sanyal was supposed to take instruction and reply.
It will be item 1 tomorrow. Okay, that number is because to freak. Say tomorrow, wherever it is. If there are some returnable motions earlier than this, those will be at the top. Thank you.
Thank you.